filed on 4/3/2024, but till date it has been not numbered. A similar matter has been posted to 11 Monday. Let the matter.
What similar arising out of the same FIR?
Same matter. Yes, ma'am.
This is a bail matter.
This is a modification of the condition of the order, bail order, which we have filed.
You have to
CRL
the same court, not this court. Somebody,
we-
some other court has given a bail. I will.
lower court has given the bail and it has been rejected. The modification has been rejected by the lower court. We are challenging that.
The co-accused bail application is there on 11th.
No, same accused CRLMC has been filed.
No.
Challenging
11th,
the
what is coming up on 11th?
11th, they have challenged the cognizance. The CBI has challenged it.
One fresh same accused?
Same accused, my lord. No, diary number.
Get it numbered. This is not done. If it is numbered, then only. Numbered and 2 o'clock you mentioned.
Deeply obliged. Deeply obliged.
Okay.
Pardon to make a mention, my lords. My lords, it's a fresh admission matter. There are two petitioners in this case who have not been added in the charge sheet. The matter is posted to 11th for the appearance, my lord.
Whatever.
Monday, I pray, my lord.
If the board permit, then only we can take it. Otherwise, how to handle it?
My lord.
Give it.
Obliged.
Yes. Fresh admission. Give. Yes.
With my lord's permission, may I mention a matter?
Yes.
My lords, this is a case where certain cattle were being transported with cruelty. And my lords, we have filed a CRLMC challenging the order passed by a learned magistrate, Baripada. My lord, Jharpagadia police station has seized certain cattle, my lords. Now there is a release order, my lords, against which I am before my lords by filing CRLMC 716 of 2024.
Who are you?
My lords, I am representing a shelter house which is located at Chakulia. And my lords, the cattle have been handed over to me. I am the affected party. And my lords, the order is for release.
There are couple of connected matters are there.
My lords, yes. And my lords,
yes. That is also that side, Baripada.
There are couple of matters.
Yes, couple of matters.
One matter was
one matter your lordship dispose of, other matters are pending.
No, one matter I kept the judgment.
Oh, sorry, it has been.
Yes.
That is right.
Just see when those matters are coming. Give the number, we'll see.
Malas, this is a fresh matter. Malas, this is a fresh matter. Malas, this is a fresh matter.
It's all right. Give
but
the number.
Malas, the urgency is there is no stay in this matter. This is a fresh matter. Filed day before yesterday. All defects are cured. I am requesting for urgent listing at 2 p.m. so that I can argue this matter for stay.
If people are languishing in the jail, that is not urgent. For cattle, I have to list it at 2 o'clock.
My lords, but then my petition will become infructuous, my lords, because the police will come and they will forcefully take away.
And
they will forcefully take away the cattle.
We'll see on Monday if it can happen. Yes. We'll see Monday. Possible put it is Monday. Yes. Yes.
Item 16.
16? Yes.
Item 16.
Is there any indication? The bail matters will be taken up?
Yes, sir.
Yes. Pass over.
17.
17 Millard. This is a Millard case 20B2B, 17 kg of ganja Millard. And from the present petitioner, and the petitioner is a local man having no anti-stand Millard.
17, 17. Mr. Maharaj.
Millard.
17.
Yes.
Same condition.
Same condition.
17. Same, huh?
Investigation on that.
Investigation on corporate.
Right.
Okay.
Item 18. 18. 19.
May I please, Lords? Well, accused in custody since 16/1/2024, alleged offense for offense under section 419, 420, 394. Well, in the meantime, my lord, article orderly seized by the police one mobile phone and 500 rupees from the present.
20 and 394.
My lord.
What is the allegation?
Mobile phone and 500 allegation. Siege already siege.
4 to 5 criminal intelligence matter as per rejection order of Florence. And also the stolen mobile phone has been seized from this accused.
How many cases you have? This is your profession.
My lord,
snatching mobile phone and this thing. He has to appear for 3 months.
criminal
The police
custody
says
matter.
3 months. He will appear before the IIC. Which IIC?
Impugnation in condition, my lord.
IIC. Sahedev Kunta. Kunta. Baleshwar.
Baleshwar. So the
Baleshwar Sahedev Kunta. PS, right? Every Sunday he will appear.
my lord.
20.
20, your lordship, offense under section 294, 323, 448, 354. Allegation, my lord, dragged her by pulling her side. Both are same villagers. There is also long-standing family enmities. Custody since, your lordship, 25/1/2024. 1.5 charge sheet has already also submitted.
See, the investigation is on.
No, charge sheet has already submitted.
Where is the charge sheet?
In fact, I have instruction that today I have taken instruction from
Let us see what has come in the charge sheet.
charge sheet has, I have not received the charge sheet, your lordship, but my instruction is charge sheet has submitted in same
What
offense.
is your name? What is your name?
My name is your lordship
Vrindavan.
Vrindavan Sahu.
Vrindavan.
The running page, my lord, rejection order, running page 16, my lord.
16.
There are two criminal antecedent.
I will clarify so far to
intelligent progress.
my lord, so far to antecedent are concerned. One antecedent is the same informant is Bhauja Tara, and that has already been settled in between.
You have the similar kind of
So far similar kind of offense is concerned, se tara ghar bhaujo deitila FIR, your lordship, due to that land dispute. I have taken specifically, I avoid in my paragraph, your lordship. That is paragraph, page 4, paragraph 5.
And for
Yes, ma'am.
3 months. 3 months.
3 months.
3
Yes.
months. stay.
Hello.
3 months. Okay.
Oh, like
21.
25, 27 Arms Act and for custody since 15/1/24. And my lord, no one has sustained any injury pursuant to the
25, 27.
my lord.
What are the weapon?
Weapon only
Country-made,
country-made pistol.
Eh?
Country-made
Country-made
pistol, my lord, on the open market, my lord, by showing that revolver to the public, making the panic situation, having with the criminal antecedent also, my lord, 4 members.
4 criminal.
Only
Yes,
for
ma'am.
that antecedent, none of the sessions are rejected.
Charge sheet is filed.
No substantial part of investigation has been completed.
Wait till charge sheet.
Charge sheet has to be-
कितने दिन लगे वो?
15/1 FIR, my lord, and custody
recent affair में
15/1.
15/1/24 affair में
Have to wait till ये मास एंट्री लगे. Sometime. ठीक है.
22.
May I please, your lordship? Matter in this case, offense under section 399 and 4025 PC, reviewed section 25 of Arms Act matter. Matter in this case, the presentation custody matter 30/11 of 2023 matter, and prosecution allegation that matter is committing for dacoit matter. The presentation nothing has been seized matter.
You are preparing for dacoity.
Yes, ma'am.
See the allegation. थोड़ा सी.
But here also, my lord, this name of this petitioner has been confessed by the apprehended accused persons. But this petitioner is a habitual offender, having with the 9 criminal entity.
9.
And
He has
same
already
out
risen
of
bail, ma'am.
one is 302 is there also.
302 is my lord, year of 2019.
Investigation is still on.
Yes, ma'am. And charge sheet was
Yes.
filed my lord 38 of
My
2020.
lord, regarding that, my lord, on the rejection order, my lord,
वो 2 weeks पर लगाओ. Take instruction. What is the charge sheet?
yes,
About charge sheet. After 2 weeks.
23.
Obliged.
23, my lord. 20 kg ID liquor seized, my lord. The petitioner is the old man of 73.
20 kg of गंजा.
नहीं ID liquor, my lord. मोहुआ जो मद 73 years old man. He is in custody since 15/1/24.
52A, 55.
Again, 52.
Yes.
Yeah, you have prepared the spurious counter liquor, my lord. And the fertilizer urea has been seized from the spot, my lord. The chemical examination report till yet it is not received.
Get the chemical line.
Chemical exam report, my lord, it will, my lord, not come, my lord, early, my lord, because it will.
No, you just see you are using 52 is
52,
55.
my lord,
there.
it is tribal
And
by
one is,
tribal by magistrate. 52
tribal
tribal.
magistrate, both, all the offenses. 273, 272.
273, 273, you are no, will not attack, my lord, if your lordship can.
Urea and all is recovered
But
from you. And
that
you
is-
are using urea
that is-
for preparing spurious, you can take the life of many people.
My lord, there is no such.
Let the investigation be complete.
My lord, investigation in the meantime, I think completed, my lord. If your lordship pass over, I will take instruction, my lord. Only pass over, my lord. If pass over, I will take
Call
instruction.
CD next week. Call CD next week. See.
24.
Yes.
I praise your lordship.
Yes.
Sir, my lord, Pindisam is the owner of a cashew factory, my lord. Sir, my lord,
Cashew factory.
yes, my lord.
Yes.
Here, adjacent to the cashew factory, the my lord, informant houses are there. They are creating disturbances, my lord. A case was registered against them when Huma police, my lord, wanted to investigate the matter. The informant as well as the brother of the informant started running. They came in contact with electric wire, which was kept for killing of boar, my lord. They came in contact, it's expired. And that ended in final report. Final report, that false case, my lord. And thereafter, she filed a complaint case. In that case, I have also granted anticipatory bail.
So what is the problem?
Beg pardon?
What is the problem now?
Now, he filed a complaint case, protest petition. Under 202 inquiry, cognizance has been taken and BW has been, I am sent to custody matter. This is the case.
And in spite of that, one of the criminal revision is pending there. And earlier also the one of the BLPL.
That is, I have also filed.
No. What is that BLPL?
BLPL, my lord.
He was in the anticipatory bail and the FIR stage.
FIR stage.
FIR stage, my lord.
Thereafter, it ended up in the final
report. I have annexed.
And protest petition is filed now. Cognizance is taken and taken into custody.
Yes, ma'am. Yes,
right now. The FIR number so and so was registered against the petitioner, next one. And the after investigation, the police after investigation, the police filed the final report on 29/4/2021. Inter alias, recording a finding that the case is false, and inter alia recording the find that no case is made out against the petitioner. At that stage, at the investigation stage, the petitioner was on anticipatory bail. Next one. Against the final form, the informant filed a protest petition, and in the said protest petition, cognizance has been taken. Subsequent to the cognizance, NBW was issued against the petitioner, and he was eventually taken into custody. On
my lord, 16/1/2024.
16/1/2024. 24. Next. He seeks indulgence of this court for admission base. The next one, the allegation against the petitioner are and granted. Okay. Yes.
25.
Currently individual condition. Yes.
25.
25. Okay. Pass over.
26.
26.
Praying for a Passover, man.
Pass over.
27.
Yes.
Petitioner remanded in this case, my lord, on dated 27/11/2023. मैंने कहीं see the affair, man. Page number 10, man.
What, you are supposed to file some bail order or something?
My lord,
What is that?
bail certificate copy not received, my lord, only bail bond furnished, my lord, certificate copy.
Now, what is that? Let me understand what is the earlier proceedings.
My lord, I am
Was related to the same incident.
one case, my lord, or two affair, my lord. Main case already released on bail, my lord.
Don't tell things in abstract. You tell what exactly, what is the fact?
Fact, my lord, kindly.
What you say somewhere and what is the case?
Case, my lord, and in the affair, my lord, allegation, during investigation, the accused has confessed that he, along with other complaints mentioned below above, the under country, made gone to hot 2 numbers of elephants, my lord. Allegation dita hathi mar deyithile only setar investigation chalthila sei case re confess kale ame bandhu ko amgar nuchei rakhichu. This is the case, my lord.
Where is the FIR?
FIR mal page 10, my lord.
10.
My lord.
What are the offenses? Okay.
25, 27 arms act. The present case.
What is recovered?
Dita bandhu ko neki dekhaichhanti gacha mulor thile.
Yes,
This is
the
But in fact, they have been involved in another case. OR number 1 of 2023.
14.
No, no. OR number 1 of 23. That is, my lord, corresponding to BCC case number 1 of 23, my lord. That case, my lord. That another.
Bail order deinante 167.
BCC number, my lord, 1 of 23. If
what happened to that in the other case you
already released on bail 167 provided.
That is, my lord, the earlier coordinate bench wanted to know whether the bail order wanted to see the bail order which he claims to be released on
bail order is not there.
Bail order not received, my lord. Bail bond furnished already certified copy of the bail bond certified copy of
if it is 2BCC number 1 of 23, my lord, then it was
14.
No, it I would have
14 of 2023.
14 of 23.
2BCC number 1 of 23 अच्छी आगना रहे antecedent reports.
Show it to Mr.
Bail order time and in that case, my lord, this petitioner released on bail 169 to proviso, my lord.
Whatever he was.
My lord.
160.
Default bail, my lord. Charge sheet could not submit it, but that is
not on merit.
My lord, not on merit, my lord.
What is happening to the investigation in this case?
In this case, investigation, my lord, has not been completed, but in fact, two contributed gone, my lord, recover on their confession and they are leading to discovery there, my lord.
27.
My lord. And the earlier case, they have released on bail 127. 167 to proviso.
How many cases you have? Only 2.
My lord, another case, my lord, here, my lord, with me. CA.
Get the CD next week. Get the CD next week. Let us see. You have killed 2 elephants.
My lord. That case,
that case, and you have got the bail because of the not filing of the charge sheet. 167(2).
My lord.
Let us see the CD in this case. Yes.
28. 28.
Pass.
29.
9 Willard. Here, petitioners, this is one petitioner, and my learned friend was appearing for other petitioner, that is connected case. Here, they have remanded in this case on 25/11/2023, when they are in custody in another case, Millard. Initially, the case was registered under section 457(380), Millard, and thereafter it was they were remanded under section 395. And here, Millard, the allegation that cash of ₹30,000 and 1 bhari 10 gram of gold was stolen, Millard, and unknown FIR registered against unknown persons, and thereafter these petitioners are remanded, Millard, from another case, Millard.
How many
and custody since 25/11.
There are two accused now.
No.
I am for one accused, Amit Patra.
I am for 4.
2 bail applications.
2 accused, huh?
Your Lordship may kindly.
First case, my lord.
First case, one petition.
One petition.
Which one? 28.
20. And Amit
Sorry,
Patra,
29.
BLAPL number 363.
Okay.
Amit Patra, one petitioner. And here
Charge sheet is filed?
Charge sheet must have been filed, my lord, because 25/11
No, my lord, charge sheet, my lord.
ହେଇଗଲାଣି time.
ଆମ ପାଖକୁ ଆସିନି ଚାର୍ଜ ସିଟ୍ up to ମାନେ investigation progress my lord so far the case
Tell me charge sheet is filed, then we will let them out.
take instruction I will take next case. CD is here my lord with me.
But charge sheet is
Charge
not.
sheet ଆସିନି final report ଆସିନି.
Wait till the
It
charge
is so that investigation progress my lord. In the meantime submitted then
Custody since 25/11.
next week my lord.
Next week our date ଟା ହେଇଗଲାଣି ପାଖାପାଖି.
ପାଖାପାଖି ହେଇନି submit ହେଇନି.
18. ଆପଣ ଖାଲି instruction ଆଣନ୍ତୁ, charge sheet file ହେଇଗଲା, then we let them out.
18.
Yes.
Item 30.
Yeah, please, Your Lords. But alleged offense is well at 353. 353 is the only non-bailable offense. Allegation is that police while were doing patrolling duty, they found 3 persons were there. Thereafter, they said that you stop there. They did not obey. Thereafter, they were chased by the police, but they did not stop. They were retained by the villagers and then police apprehended. Apart from these 3 persons in the motorcycle, other persons were there, the petitioner were there. How much 353 will be applicable? We have not disturbed the public. Police.
There are other criminal antecedents petition my lord.
Only
so far
by
the
ground.
CD is not received my lord.
353 re magistrate tribal offense that way also not made out. If my friend, my lords, senior can say that 353 will be also made out if we will not obey the order of the police. Instead, mamu koile thiya hua pai ame thiya lenu padelu. How 353 will be applicable? For that reason, we are apprehended and remanded so many other cases. So considering I have pardon?
How many cases you have?
More than near about 20 cases.
20 cases.
20 cases.
For that reason, my lord, case is required, my lord.
I know that. My lord, if I got the order from your lordship, I will not be released at present. But certainly, why in this case I will not be granted? I will come to the Hon'Ble High Court. No, 353. You say for 353 we are coming to the Hon'Ble High Court. For 350 only because of antecedent.
I will release him 6 months. He will appear before the police because of the antecedents. But he can't come out. I don't.
Yeah, I will not be come out from the. But certainly, why for this offense? For this offense, whether I will come to the Hon'Ble High Court.
For taking into consideration the fact that the as many as 20 cases. 20 cases. He can appear before the which police station is that? Appear before the Soro police station. PS Soro every Sunday for 6 months. Granted.
Pardon. Previous item number 28. I just missed.
28. Take it. Bail. Yes.
28. Well, it's a case under section
30 my lord dispose of. At 30 dispose of.
28 20B2C of the NDPS Act.
What is the recovery?
CD was called for.
Recovery.
Well,
how much is recovered?
40 kg, my lord, 40 kg, 305
kg, 305 grams.
And criminal case is there, my lord, against him. For that, it should not be released on bail, my lord.
Against whom?
That is likelihood of committing similar.
Which
against the petitioner.
Yeah, he is in custody since?
And in custody since, my lord, 6/11/2023.
And what about the other case?
What is
He has another case.
Antecedent said that another case 20B NDPS Act. They are, my lord.
What is the recovery
against the petitioner?
What is the recovery in that case?
That is not come, my lord. CD reveals that only the IO mentioned the case there. There is another case against the petitioner.
Is he on bail on that case? What is
here to my lord furnish.
Let me give
comprehensive
number. I will obtain it.
I will give it.
Just
take
give
the
me
number.
number. I will obtain it.
31.
If you are already on bail in that case, you will get the bail.
My lord, I'll just.
Yes, 31.
May plus.
Yes.
307 and other related offences. Here the two injured persons are there. The one injured have annexed their injury reports under annexure to 3 series.
307.
Yes, madam. That Gopal Butel had sustained 2 injuries at that page 18, my lord, kind of glance. One is grievous and another was not, my lord, opine.
Which part of the body you have?
That is on the head, as is stated. On the head. The to, my lord, the petitioner and that injured there, my lord, belongs to the same family. There is a landed dispute. They have, my lord, retained the share of the present petitioner for which there was a dispute, and both of them assaulted to each other. The present petitioner also sustained injury. No, I have not lost affair.
Show me your injury report.
That I have annexed, madam.
Your injury report.
I have annexed page 15, madam.
15.
Yes, madam. 16 is the relevant
This
portion.
is
2 injuries.
For that reason, my lord, since that is not readable, for that reason, this honorable directed me to obtain the, my lord, the visible injury report, my lord. For that reason, I got, my lord, again, my lord, injury report. There are 2 grievous injury, my lord. One right frontal head, that is by means of
page 16.
Page 16 ଟା ହଉଛି ମୋର
ନାଇଁ ଦେଖି ଗୋଟେ memo ଦେଇଛନ୍ତି
I have 1 minute. Don't confuse about it.
this honorable court directed the state council to obtain the
Bhaktavandhu Patel is the petitioner.
Patel.
He is the petitioner.
He is the accused.
He is the accused.
You have sustained also injury.
He also injuries.
That is 2 simple injury. All simple injuries.
Yes, ma'am.
Simple injury. What about the victim?
Victim sustained 2 grievous injury, my lord. One is the head, frontal head, my lord. By means of, my lord, the Honda. That is mentioned, my lord. For that reason, I have obtained the instruction.
Charge sheet filed.
Charge sheet not submitted.
Another nasal bone, lords. Another
grievous injury.
ନା 49 ପଡିଲା ବେଳୁ fracture.
Grievous injury, nasal bone.
Both injury are grievous.
My lord, the statement, my lord, reveals that from the
injury
nasal bone, my lord, nasal bone.
Having no criminal antecedent.
Only thing is, he also received injury.
Yes, ma'am.
The free fight.
Yes, ma'am.
But in fact, my lord, since charge sheet has not been, we have to wait.
Charge sheet.
Yes, charge sheet submitted.
Charge sheet.
Let him move after. No, charge sheet submitted.
File.
Certified copy of the I am giving.
Bring on record.
Certified copy.
This is bail matter.
Yes, ma'am.
Online. Everything is online. File it.
File it, yes.
18.
Yes, ma'am.
18. Yes.
32.
That's the only point he has, because he himself has also received.
And having no criminal antecedent also. Past offender.
One is enough. One attempt to murder is enough.
Attempt to murder.
And the final part of the body.
No, that was assault by he, my lord, stated in the
one custody since
in month of October, my
October
2023.
23.
Set up assaulted.
18.
Yes.
File the charge sheet.
Yes, my lord. In the meantime.
Yes.
32.
I am appearing for the informant. Let them serve a copy, my lord.
I'll serve a copy in course of the, let it come on Monday, my lord.
What is the offense?
Offense 354. POCSO Act.
354.
He has taken some nude photographs. Threaten, give 1 lakh rupees, otherwise I will.
Not to the concerned victim, to the father of the victim. And they have previous village dispute is there. Admittedly, that is there.
He will not give 1 lakh rupees. So only the father will give.
My humble officer, victim has not been directed or instructed to pay him.
164 recorded.
I got you.
164.
164. Already you received last occasion directed the state council, coordinated by directed to obtain the photograph. If you receive wants.
164 statement is not there.
Okay, 164.
164.
Let them serve a copy, my lord.
My friend, I like that. ଗୋଟେ ଗାଁର ପିଲା 2 ଜଣ ଯାକ ସେ ବି କହୁଛି ଛୋଟବେଳୁ ଜଣାଶୁଣା ଅଛି ମୁଁ ମାମୁଙ୍କ ସାଙ୍ଗ ହୋଇଥିବ ତାଙ୍କ ଘରକୁ ଯିବା ଆସିବା ଥିଲା ମତେ ଭଲ ପାଇଲେ ବାହା ପାଇଁ କହିଲେ ରାଜି ହୋଇ ଯାଇଥିଲି ଦିସ୍ ଇଜ 164 ଷ୍ଟେଟମେଣ୍ଟ
34.
May I please, your lordship? There is a direction for production of CD. Last
Yes.
CD asking.
Also, my lord,
Another time given,
here the postmortem report, the cause of death has not been reflected because viscera has been sent for chemical examination. So that may be called for.
Well,
Because he was a registered medicine practitioner. He gave an injection to injured person. He died in hospital. Then he has been first aid on a section 304 and 417, 418, 419 import section. But I have annexed the certified the copy of my
You are the doctor.
quack. That is earlier lordship knows LMP and RMP. So he is one of the RMPs.
Okay.
That certificate has been very much seized by the police officer, but nothing has been reflected in the case diary.
the case diary already
Victim-
confirmed twice. my lord.
He was suffering from what?
He was while cutting a tree, if
down.
one of his finger caught by axe, then he fell down. So I think for coagulation of blood, he might have injected any medicine. Then he was taken for better treatment to hospital nearby CSC. There he died. So thereafter, this one of the villagers, the informant, he came forward due to he had given the injection. Out of that, he has died.
By the time, by the way, how many people you have killed so far?
No, but not
The
yet.
treatment.
Not yet. Not yet.
CD does.
So, Lekhi FIR, my lord, there is a specific allegation that I don't possess the qualification or the certificate.
Page 15, the certificate
Yes,
is there,
yes, my lord.
Institute of Alternative Medicine. Medicine or medium?
Medicine.
Medium you have written. Where is
Medium.
the original?
Original is just the pachpad roich. Muda type korchi because not legible one. I've
Medium,
given
what is this? This is doubtful. Medium, what is this? Institute of Alternative
Medicine.
Medium.
medicine, my lord. Alternate
What?
medicine.
The original says like medium. What is medium? You have written medium only. Original is also medium.
Jahatla Siddham Lekhichu. Say certificate of police is
And which
purchased.
is the original one?
My lord, the page, next page that was
Original
not.
or medium likha hai thi.
I guess
Doubtful. The certificate is doubtful.
that has to be verified, my lord.
He
Instruction
verified the
also.
certificate.
My
If
lord.
he has a valid certificate of quack, wrong, right? He had no intention to kill someone.
My lord. Yes, my lord. That
He
was.
might have treated. He is not a good hand. What to do?
My lord. He is known as a quack in that area.
But the only verification has to be done whether he is validly practicing as a
Quack in that area.
I'll take instruction, my lord,
in the
regarding the
alternative medicine.
regarding the genuineness of the
Yes,
certificate. I will take
annexed.
instruction.
That was the
Government
direction.
of West Bengal.
That was the direction. That was sorted. Lots of my fees sorted.
Huh?
Sorted.
Sorted. Auto nahi.
My lord. Obliged.
Mr. Ragada, learned counsel the petitioner seeks time to verify the genuineness of the certificate filed by the petitioner under Annex 3. Release the matter on 19th.
And also CD and
CD is already there.
My lord, my lord.
If I'll satisfy that this is a genuine thing, then you are entitled. Yes.
35.
May I please, yours? My lord, FIR register, my lord, 498 302 34 IPs.
Yes.
But subsequent to the petitioner was arrested under section 498 306. And charge sheet also submitted 498 306, my lord.
CD case that required. CD task.
306.
306,
does-
my lord. Charge sheet
Charge
already
sheet
submitted.
अच्छी अच्छी
charge sheet ଲେଖା ହେଇଛି ଭାଇ
charge sheet ଅଛି, ଦେଇଦେଲେ ଆମେ-
charge sheet ଅଛି ବାପା
You are in custody since?
charge sheet my lord 13/12/2023
Suicide note, anything is there?
Such CD.
suicide medical report is there hanging
Hang, that's right. Any suicide note?
not
Any suicide note is there recovered?
hanging the
अरे hanging और suicide note लिखी hang करिची ना कौन? What is this?
husband character ने संदेह कला से outside ଯାଇଥିଲା at the time of occurrence husband was absent in the house she committed suicide by
I am asking something else.
Suicide note?
Whether there is any suicide note?
That's in the charge sheet that are not mentioned, but I have to obtain instruction on one. Already, my lord.
19.
36.
If there is no suicide note, nothing, then 37.
the short death by lord
19. Yes.
36.
Earlier, there is a direction to serve a copy. Let them serve a copy.
You are informant.
302.
302 is allegation है
Why are you after Mr. Chand today?
The question.
3 hearings has taken place. What is this? Only before petitioner. What are the allegations?
allegation allegation nahi. Allegation was that the 3 persons were named, specifically named in the affair. Those persons have committed the crime. Allegation after the particular occurrence was
You
over.
show me the injury. 307, na?
302.
307 converted to ammonia allegation of assault is not there. I have given the copy of the affair, but allegation is that after the occurrence was
Charge
over.
sheet is filed in 302.
Separate instruction in the meantime. But I will keep it after 2 weeks. In the meantime,
After 2 weeks.
37.
My lord, I may be permitted to withdraw.
Withdraw. Very withdraw.
38.
May I please? My lord, alleged offense is offense under section 302, 34 of IPC, my lord. This petitioner is custody since 25/2023. Allegation is the deceased was working as a truck driver of the under the petitioner, my lord, on 16/5/2023 at about 11:30. One Deepak Yadav, one of the co-accused, took her husband from her house, working him up from sleep by saying that there was some loading work. My lord, next day on 17/5/2023 at 2 p.m. Deepak and Ashish brought her husband by motorcycle in an unconscious condition. Thereafter, deceased condition was serious, and they took him to hospital. A doctor declared it dead. This is the allegation.
Who are you?
I am the owner of the truck, my lord.
That's it. Filed.
That's it, fine. But since a case, I would like to, your lordship, bring to the PM report. There are 10 injuries. Let's look at it. There are 10 injuries.
What is 164?
164 is there. I will come to that. But the sum total of the fact is that the deceased was working as a driver in the truck of the petitioner. He did not want to drive his truck. The petitioner wanted that you have to drive in my truck unless you will not drive any other truck. That was the dispute between the parties. Now, when he denied to drive, one of the occasion, the brother of this petitioner went to the house of the deceased and forcibly took him to drive his truck. Thereafter, in the evening, he left the deceased in the house of the wife of the petitioner, wife of the deceased, and said that he has took alcohol. In fact, the alcohol was not found in the postmortem report. Number one. Number two, when the deceased, after being given water by his wife, he stated before his wife unconsciously with a slow voice that this petitioner and his brother brutally assaulted him and so threw him in the ground. Thereafter, he was taken to the house of the.
Then there is a dying declaration.
Yes, that oral dying declaration has been made before the wife and before the son. They have exactly stated in with the important.
What is
important
164?
Words. Yes, that I am reading.
Which statement is this?
The camera. Wife of the Sarita Devi is the wife of the deceased.
Before whom that dying declaration?
Dying declaration made.
Yes. Yes.
Patika Dre.
811, my lord. Your lordship is kind of a glance to the 164 statement of the victim, my lord.
Got a minute. Lots of first the procedure is to be followed. 376(3) is there. So we have,
notice.
yes, notice.
Notice, my lord, notice they will never receive, my lord. You have to see the input order.
What that's the procedure? What to do?
And notice your lordship has already issued.
Notice issued?
Yes, already issued. And the endorsee has reflected that the address is found absent and he is nowhere. And your lordship can turn to page 12. Page 12 is very important.
Yes, notice was issued.
Only because of that notice, my lord. Page 12, para 5, subpara. The informant come mother. My lord, the word started.
Yes.
The informant come mother of the victim neither turn up after sufficiency of a service of notice upon her, nor did she supply the correct and current address of her victim daughter to the IO. In such a situation, the accused cannot be allowed to wait for uncertain period for consideration of the bail application. So this amounts to the notice. Just now your lordship on previous occasion has served the victim, but nobody is there to accept, and it has returned undelivered. So how could this possible to serve the notice? So notice part is over. Observing this part,
yes.
The reason
Come,
164 million. 164 million.
160.
ଗତ 2 ବର୍ଷ ହେଲା ମୁଁ ଓ ସୁଚିତ୍ର ନାୟକ ଆମେ ଦୁହେଁ ପରସ୍ପରକୁ ଭଲ
File to go.
well I have file net copy.
Yes, that is there. He has also given.
I have also original copy.
Yes.
Madam.
I got it.
Thank you.
Your police part number 3. First, click to the accused. First part. However, none entered appearance on behalf of the victim. While the bail application was being dealt with by the court below, the similar attempt was made to serve the informant and the victim. Despite repeated efforts made by the trial court, the service could not be effected on the informant. The trial court inter alia has recorded the said fact. Page 12, it lead to the para 5. The informant come mother to consideration of bail. Okay. Therefore, despite service, the informant and the victim did not appear. Peruse the statement of the victim under section 164, recorded under 164. Here, the victim in her statement of 164 CRPC inter alia stated that she was in love relationship with the accused, and she had insisted the accused to accompany her. Accordingly, the accused one fine day took her. What did we call it?
ସେଠୁ ଆଜ୍ଞା ସେଠୁ ଗଲେ ପୁରୀ ତାପରେ ଗଲେ କେରଳ ସେ ସୁଚିତ୍ର ଫେରିଲୁ ତା ସେଠାରୁ ଭୁବନେଶ୍ୱର ଗଲୁ ଓ ସେଠାରୁ ଆମେ ହାଇଦ୍ରାବାଦ ପଳେଇ ଗଲୁ ଓ ସେଠାରେ ଦୁହେଁ ମିଳିମିଶି କାମ କଲୁ।
Thereafter they went to Hyderabad. Since the what is the age of this girl?
So that time she was 16 plus.
The victim was 16-year-old. Section 6 of POCSO has been invoked on the predictions. Taking into consideration the statement of the victim under section 164 CRPC and the other circumstances.
This is a case under section 20B 2B of NDPS Act, my lord. Only 12 kg has been recovered from the possession of the petitioner, my
12
lord.
kg.
12 kg.
Only 12
Man
kg.
of West Bengal or Assam?
Any West Bengal?
West Bengal.
Okay, granted. Yes.
Obliged, my lord.
Yeah.
Item 1.
My lord,
Yes.
on the basis of complaint, petition filed by the Open Note 2, the case has been registered under section 323, 494, 498, 109, 25, 506 and 34 I will ask. And petitioner 1 is the husband my land.
NBW, NBW, you are on bail.
No, my lord. Someone issued to him. He did not appear.
Ah.
For that reason, someone made sufficient. Thereafter, immediately issued. by
Anyway,
court.
he will appear. Appear first, 30th or 5th court, 5th April, on or before 5th. 500. When NBW was issued? 22. Okay, 500. Appear and seek remedy. Okay.
Item 2. Warranty for the
Yes.
Ma'am, please.
Yes.
This is second.
Why there are so many hearing here?
Lordship,
1,
they-
2, 3, 4, 5, many here. Anyway.
My learned wanted to produce records.
No.
Uh,
Record is
till
in
now,
the court.
for
Yes, I have
my-
received the charge sheet also in the record.
Uh,
Let my learning.
Yes. Are you ready to, or you want time? What exactly you want? The body language indicates that you are not ready.
Lordship, partly ready because I was told that Lordship will not sit at all lunch.
No, not like that. If you
So
are ready, it will, how much time will you take it?
At least half an hour, more than half an hour.
Half an hour.
Any other day in the April.
Okay.
Interim order to continue.
Short date.
A short date only.
April.
Yes, I think I heard.
Partly Lordship had, and what is the important Lordship wanted, me the first charge sheet and the second document, which is with them. I have got the copy. Original copy, if they can bring it and show to my lord.
That's all right. Original not required. You have filed everything.
I have filed second charge sheet. First charge sheet is a huge volume. If they can bring, I have got the Xerox copy.
Okay, we'll hear, no problem.
Let's
No need to file.
let's see.
Yes.
Then April 2nd or 3rd week.
No, short date, my lord. Short date interim order is there.
Short date
And
will
it's
be,
Short date only.
30
short
crores.
date will be April 2nd or 3rd week.
30 crores.
Yes.
Not 30 crores has not been seized from us. This is
And it's
there's
the-
a 3 crores, then 30 crores. Interesting.
Anyway, it is in crores only.
No, Lordship. I am poor lawyer, Lordship. No, Lordship.
He become poor because of you.
No, Lordship. No, Lordship.
30 crore become 33 crores.
Lordship. April 2nd or 3rd week. Let's interim order to
Interim. Yes.
Item 3.
May I please? The present petitioner, my lord, challenge the cognizance order of the land court below, my lord. The fact is like that, my lord. I kindly see the FIR, my
What is
lord.
this order? 31/3/2023? Annexure 3.
And so 3 is the cognizance order, my lord.
Okay. You are challenging cognizance.
Yes, my
Yes, tell me.
The fact is, my lord, like that. The page number 9, my lord, the FIR story, my lord.
9, huh?
9, my lord.
Okay.
After getting the reliable.
Show me the charge sheet.
Yes, my lord. Charge sheet is, my lord,
Yes.
page number 11.
Right. Come to the allegation.
Yes, my lord. The page 9 is the allegation, my lord.
Hmm.
The FIR story, my lord, after getting the reliable information, the IO, the reading party, would apprehending the accused person, my lord. And they found presence of the witness, found 1 9mm pistol from its waist, seemed to be loaded with ammunition, my lord. They found the 1 9mm pistol from the position of the accused person from his waist. That is story, my lord, in presence of the two witnesses. After completion of charge sheet, my lord, investigation, the IO submitted charge sheet, the page 11, my lord.
Yeah.
Under section 25 1BA of Arms Act, my lord.
Now come to space 60.
60.
16.
16, my lord.
Now what are the allegations? What is your name?
Sheikh Babu, Boren Babu. The sole petitioner.
Sole accused.
Sole accused.
Okay, come on, read it.
Yes, ma'am. The personal search in presence of the witnesses and found one 9mm pistol.
Where are you reading?
The page 16, my lord.
One
Yes, my lord. The
Charge
middle
sheet.
portion. Charge sheet. The fact of the case.
Yes.
The middle portion, my lord.
Yes.
Personal search in presence of the witnesses, my lord. Already got it.
Yes, read it.
Yes. And found one 9mm pistol from his waist seemed to be loaded with ammunition, my lord. On being asked, he failed to produce any document regarding possession of such arm. On verification of the arm, it found that the magazine is having 6 rounds of 9mm live ammunition, my lord.
Yes.
Yes, my lord.
Found
So
that
the
magazine is having 6 rounds of.
the possessing the firearms, the section 25(1)(ba is made out. No doubt, my lord. Now 25(1)(ba also I am reading, my lord, to answer 25(1)(ba.
Then you want that in the cognizance stage.
Yes, my
I
lord.
should alter the.
No, my lord. My lord, kindly see answer 3, the 27th
What is
page.
your
number.
case then?
My lord,
This is
cognizance is
an
taken.
admitted by prima facie case is
Yes,
made out.
yes, 25(1).
Instead of one offense, other offense cognizance.
Cognizance taken.
And
Taken.
you can argue that on the charge.
Yes, ma'am. No,
You
ma'am.
say that 41 is not made out, 25 is made out, or 27 made out.
No, my lord.
In cognizance case, why should I get into the merits of the case?
Because, my lord, 25.
I'm giving that liberty. You go and argue.
My lord, only once. 25(1)(a in the taken cognizance, my lord, not made out. Because I'm reading, my lord, 25(1)(a and 25(1)(ba. The second.
What is made out then?
25(1)(b) is made out.
Made out?
Possessing
Then
this, my
tell that to the court who is framing charge. I'm not framing charge. I'm not framing charge. I'm giving that liberty to you. That is the right way of doing. The constitutional petition seeks to withdraw the present petition to raise all these points, all the points available to him at the stage of framing of charges. With this liberty, the petition is disposed.
One submission, man. That after the 151, 125(1)(a is the life imprisonment, man. So he committed to the sessions, man. Then the session after framing of charge, before framing of charge, we file a discharge petition, and the is confirmed by the Lane session judge, man.
Discharge petition you have already filed.
Yes, my lord. Discharge petition already filed.
Now,
this is my lord cognizance stage, my lord. I'm challenging the cognizance.
after your discharge petition is
The pending in this case is pending this honorable court. The Lane magistrate, my lord, committed the offense to the session.
anyway, you moved an application for discharge.
Yes, already
which
confirmed.
which is turned down.
Yes, ma'am.
And against that, you have other remedy. Cognizance you can't.
My lord, the cognizance is there, my lord. Is the order is there?
That the petition seeks to withdraw the petition. And during the pendency of this petition, during the pendency of the present petition, he moved an application before the court below seeking discharge under section 227.
Yes, ma'am.
227 CRPC. The application has been turned down. Turned down. Therefore, the petitioner seeks to withdraw the present petition to avail the remedy under law, so as to assign the order by which his application under section 227 CRPC is rejected. It is accordingly the petition is disposed of with aforementioned liberty. Yes. Yes.
Item 4. I play for 2 weeks time, my lord.
Okay.
Item 5.
My lord, item 5, I prefer adjournment. Obliged.
5.
Item 6.
Obliged.
Pass, my lord.
Pass.
Item 7.
7, my lord. Here is a case, my lord, where I have challenged the order under Annexure 4, in which, my lord, a petition filed under section 397 of CRPC for revision of a order was rejected on the ground of maintainability, my lord. Because the background of the case is that, my lord, the ancestral property of the present petitioner was, my lord, encroached by opposite party number 2 to 4, my lord. And thereafter, I have filed a petition under Annexure 1 under Section 144 of CRPC, my lord. And in that case, Your Lordship, a joint inquiry was conducted. Your Lordship may kindly turn to page Annexure 2, the joint inquiry report, that is at page 16 and 17.
Yes.
16, my lord. Your Lordship may kindly find at page 17. Sorry, my lord. Page 16 and 17, Annexure 2. This joint inquiry was made by Inspector in charge of
Anyway,
KNWAGA.
in view of the above stated material fact, the present circumstances in the field,
There is
there is
apprehension
apprehension of
breach of peace.
Yes.
In my favor, this inquiry report was submitted, my lord. Thereafter, my lord, I have filed a petition for conversion of the that case under section 144 to 145 of CRPC, my lord. And on that, my lord, the learned SDM by the order dated 21/9/2022, that is at page 21. Your Lordship may kindly find page 20. Annexure 3, page 21, my lord. Last, the relevant portion is at page 21.
Yes.
Your Lordship, under the heading order, it is clear that disputed land under possession of the opposite party member since long with illegal possession as per report of Tahsildar so and so, my lord. There, clause 2, the prayer of advocate for the petitioner is not acceptable to convert the proceeding under section 144 CRPC to under section 145 of CRPC. And last, my lord, 3, the petitioner can take shelter in proper court of law for his claim of possession of the suit land. And 4, the IIC KNWAGA police station is directed to keep close watch on law and order situation about the disputed land and take action as per law. Drop the case, my lord. This is the wording, my lord. And thereafter, challenging this order, I have filed a revision under section 397 of CRPC. And that is that order, impugned order is at Annexure 4, and the relevant portion is at page 20, sorry, my lord, page 26, my lord. Your Lordship may kindly find at last 4, paragraph 4, my lord. Any order which does not deal with the final right of the parties but is made before judgment and gives no final decision on the merit, the dispute, but it merely on the matter of procedure are interlocutory. They say that this is interlocutory order, but here, my lord, nothing.
Let us issue notice. Let us see.
Yes, my lord.
Issue notice.
Issue notice to private parties, and till then, my lord, I have filed a miscase.
Yes.
I have filed a miscase to direct the opposite party, my lord, that to maintain status quo, my lord. Only status quo till next date.
No.
My lord, they will construct, my lord.
Convert it to the civil court.
Exactly, my lord.
ATM says that
Exactly.
Explore your remedies.
He has to
as it is.
civil court, my lord.
As it is, jemti achi, sem thau.
In a 144 proceeding, you have filed a petition which is not maintainable. You are challenging that. You are asking for status quo.
No, it is, my lord, the revision against revision order.
You have to see whether it is maintainable or not.
My lord.
Second, your right will be decided by the civil court. That's what the SDM says.
Yes.
It is a 144 proceeding. Where is the question of status quo? Only notice.
Only notice.
Notice and date may be fixed.
No, not date. Yes.
8, my lord, kindly next week, my lord.
8.
Next week.
May please.
Information
is a customer who has purchased a Toyota car.
Enter allegation is deficiency in service, the low mileage, etc. etc. Instead of choosing the right forum, the FIR has been lodged and that has been registered against some of the directors and the employees without implicating the company as accused.
Let us see the allegation.
Yes, sir. Last lawsuit, sir. I have.
Last lawsuit direct him to amend the petition.
Informant,
That
I
if
have
that
made-
allow, notice will go to.
Notice, let notice go. It is a allegation is regarding deficiency of service.
Yes, sir. Yes.
You are on bail?
No, for the proceeding.
OP to notice.
The notice I am sending, but are you on bail?
No. I am seeking for quashing of this proceeding.
Why have you not got the applied for bail? Let us see allegation, page 21. Let's see.
Page 21.
The Toyota company.
I Sanjay so I purchased a Toyota Etios Liva small range from Toyota company. So it's exclusive dealer Field Motors Private Limited. Field Motors Private Limited has not been implicated as
anyway. You don't
registered in local so and so.
The company provided
A manual along with warranty card that in the event of minor, major and manufacturing defect of the vehicle within warranty period, the company through its authorized dealer would remove the defect. But the not only the company through its vehicle manual defect, the sold car would show a mileage of 23 per liter, but after run the vehicle it failed to ensure the performance in the front of mileage. Truly the car showed the mileage to 10 to 12. These are the and also page 49. The mileage, so far as the mileage is.
Let us read it.
Yes, sir.
You have not completed the sentence, you are going to what?
Yes, sir. For diesel. Being aggrieved, I through my son Sanjeev Marda got it verified by very often in the service station of exclusive dealer of Toyota Field Motors Private Limited at Kotak during a free service period of vehicle, but the vehicle showed no improvement in mileage from the company as well as its dealer started consoling me that the vehicle would gradually show good mileage as per the mileage guaranteed in the vehicle manual if the vehicle would complete run after around 20,000 kilometers. In spite of that mileage status was not at all improved, but gradually. The vehicle registered other defects like engine sound and vibration of the body of the vehicle and low mileage. Last year on 27/12/21, the vehicle registered a manufacturing defect for which the.
Yes, I got it.
Yes.
This is only deficiency of service. Nothing.
Notice.
And I'll stay the further.
Malad. Yes.
Yes.
Okay.
Right.
Okay. High
So
level.
notice to opposite party number 2 in the internagnum. The further proceeding. Where is that?
Further proceeding in the Hon'Ble PS case number. GR case number.
GR case number.
GR case number 33/23.
Pending in the court of SDJM. Hon'Ble.
SDJM Hon'Ble.
Is state further.
High
Further
level.
on. Yes.
That's
52.
52 na?
52. Yes.
Item 10, ideally it should be a writ application because I've challenged quashing of a lookout circular, LOC, wrongly some.
Then you take.
Withdraw. I withdraw with the liberty to file a writ application.
You have the liberty.
Lordship,
Okay.
name it.
When Constable, the petitioner seeks to withdraw the present petition to avail the remedy under law.
Writ.
Aforementioned liberty.
Because I have to make Bureau of Immigration also, but these are not been done in this.
Okay, no problem.
Deeply obliged.
What is 52 now?
This is the matter where
private.
Yes. Yes. 50.
Milord, the vigilance case was triggered against me and my wife, Milord. And the property is were attached by seized by the Vigilance Department.
Mhm.
And thereafter, my lord, I was enlarged on bail. My wife was on anticipatory bail. And on various applications filed before the Learned Trial Court, Vigilance Court, and before this Honorable Court, the property seized by them were released, my lord. And I have been able to, my lord, breathe at least to some extent, to some extent. Now, as the matter stood, my lord, now under the Prevention of Money Laundering Act, my lord, the officer started, my lord, investigation and calling us a number of occasions to collect materials. Then I approached this Honorable Court. And this Honorable Court, what you will find in the earlier order, page 86.
Page 86. Yes.
My lord, all these, my lord, the reasons for which the PMLA, the proceeding before the PMLA would not lie were being argued till page 84. And your lordship will find in page 84, paragraph 5.
84.
Yes.
Hmm.
Mr. Gopal Agarwal, learned counsel for the opposite part number 3, submits that the challenge to the summons and the proceedings at this stage is premature, as the, well, this is very important, as the summons in the exercise of power under section 50, subsection 2 and subsection 3 of the PML Act has been issued for the purpose of inquiry and investigation only, and the petitioner is not an accused in the case. He should therefore have no apprehension of being arrested on his appearance before the opposite part number 3 in response to the summons by the annexer 2 with documents sought
Now
for.
the complaint is filed under 44.
No, not filed.
Well, see, then he should therefore have no apprehension of being
Yes.
arrested, so and so.
Uh,
A
the-
complaint under section 44
1B
of PMLA
will be filed against
will be
him
filed against him
after examining material.
available against him.
Yes.
The petitioner is yet to submit the copies of the document to so and so, so and so. To further submit that, they will instruct the department to grant time. Yes. Now what had happened?
Now, my lord, now they said there is no apprehension. There is no proceeding as such initiated against me. Well, all of a sudden, after I moved your lordship on the last occasion, when time was sought for on 2 occasions by the my lord concerned PMLA, the authority, after I moved my lord in the notice of attachment, an attachment order, my lord, the most my lord, sorry state of affair is that the attachment order.
The attachment order is passed without issuing the notice to you.
No, notice. I have been, my lord, asked to submit certain documents. I submitted.
You participated in that process.
I participated. Not only me, my lord, my daughters who are staying in Ireland.
Right.
They also came here to participate in the proceeding, my lord. My wife also participated. We all participated. We submitted the explanation, my lord, everything. Income or expenditure, assets, everything to them, my lord. Now, without considering our explanation, they attach the property, and the most shocking affair is, my lord, I am retired. My pension account has been attached. My lord, my pension account under no stretch of imagination can be said to be a proceeds of the crime. The attached, my lord.
So what is your grievance? The entire attachment you are telling me.
Yes. Now I have filed an interim application, my lord, for that, and lordship will.
Interim application for what?
My lord,
see, the entire attachment
Yes,
can't be
yes.
the pension part. I can understand. That is yes.
and other aspect, the attachment of other properties, my lord,
Yes.
which they have made, it is in an essence, my lord, overreaching the order of the Learned Trial Court and this Honorable Court. And I have approached the Learned Trial Court, my lord, under the PC Act, my lord, there for releasing from the attachment. The trial court passes the order to release those properties. And those things have been attached also. But let me kindly explain to your lordship what is the purpose of attachment. Lordship may kindly say section 5 of the PML Act. Well, that this is this act is a purpose of legislation.
PMLA. Pension of money laundering. Yes. Yes.
My lord, though it is a purpose of legislation, my lord,
Yes.
but the conduct of the officers have made it draconian, my lord.
The law itself is
No, law is purposive, my lord. And Lordship knows very recently, day before yesterday, Honorable Supreme Court quashed the entire proceeding against the Deputy Chief Minister of Karnataka.
That's right. Yes, 5.
Where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reason to believe, this is very important. The reason for such belief to be recorded in writing, I can demonstrate how this reasoning is omnibus in the present order. On the basis of the material in his possession that any person is in possession of any proceeds of crime, and B is important. And such proceeds, that means that proceeds only of the crime ballot. Here pension doesn't come under that ballot.
Right.
Such proceeds of the crime are likely to be concealed. These are the aspects. Either to
The
be concealed.
property has to be relatable to the proceeds of the crime. That's what.
That's all. Exactly.
Yes.
Concealed, transferred, or dealt with in a manner which may result in frustrating any proceeding relating to the confiscation of such proceeds.
Show me what are the property which are confiscated.
Yes.
What are the property? List of the property. Where is that order? Impugn order?
Let me kindly see.
Please see the list. First, Annex 2. Is this the list? No. No. See that.
In fact, before going to that, I was just trying to impress upon your lordship by showing a judgment of Honorable Justice Sankar Mishra. This is the reason I was not very sacrosanct on that day. If that order had been passed, probably I would not have been slapped with this kind of attachment order. Lordship may kindly see that order at page 76.
76.
6 of the main application.
Okay. Yes.
Sridas, the National Council Petitioner, and Mr. Swenso. This application under Section 482 CRPC has been filed. I'm skipping over.
Yes.
Then para 4. After hearing the counsel for the parties at length, this court is of the view that since investigation is in progress, the explanations submitted by the petitioner before this court with regard to her income and expenditure, etc., can also be raised before the investigating officer, and hence liberty is granted to her accordingly. This was by my wife, Palai. It is directed that the IO shall duly consider the explanations and documents as may be furnished by the petitioner in support of her contention and in accordance with law. It is open to the investigating officer to ask for and retain any document from the petitioner, but only after furnishing photostat copies thereof to her. Well, if this order had been passed on that day itself also, my lad, I think probably this would not have been slapped on me. I gave everything, my lad. And your lordship will see, I have given a tabular form. What is my income expenditure? What is my wife's income expenditure by supporting materials? My daughter staying in Ireland also placed very high, my lad. Their income expenditure.
They might have considered all these things.
No, that
Let's
is.
see.
Yes.
Where is that?
Lordship will see page 26 of the interim application. That is the order of attachment.
26 of
Interim application, Annexer 15 collectively.
Yes.
And Lordship can see paragraph 2. What is the genesis?
I have considered.
I have considered the facts and circumstances of the case and evidences available on record, including the following material. What is that, Pelad? FIR in the Vigilance Department case. No, that became the substratum here. What was the FR amount in the Vigilance Department? The very same amount verbatim has been put here.
Union Bank
and so Bank. And Lordship will kindly see page 27. Statement of Sanghamitra, my wife. Serial number 14.
Yes.
15. Statement of Arpita, my daughter. 16. Statement of Ankita, my daughter. And then, Melad, 26. At page 28, statement of Archita, my daughter. My statement is not there.
And now, what are the...
And now, Lordship kindly come to the background of the case. And FIR at same page, paragraph 3, Melad.
Yes.
3.1, and FIR number 23 of 13th August 2020 was registered by the Vigilance Police Station, Bhubaneswar. So, Melad. And then 3.2, as per the FIR,
What happened to that predicating offense? Trial is on.
There, charge sheet not filed as yet, my lord. Well, if there is something against me, charge sheet will be filed. 4 years, no charge sheet.
Okay. As per the FIR,
As per the FIR, on the allegation of possession of huge disproportionate assets of Sri Das,
3 crores, how much?
79,538.
79,000.
Well, the income of my wife, my daughters, everything has been taken here.
They show me the properties.
Well, properties, Lordship will see.
What is the check period?
Page 52, my lord.
What is the check period? Check period?
But check period is from 24 to 86.
24
to
86 to
24th of February 1986 to 12th of August 2020. 34 years, my lord. My entire service career.
Yes.
Lordship can come to page
Table 1.
52, my lord.
Page 30, table 1.
Not page 52, my lord.
52.
Yes. My lord, these are the properties attached, my lord. I have given the details.
Yes. Yes.
My lord, this is the property. This is the property they have attached in their, my lord, in their order.
Savings SBI. Yes. Bank account.
And your lordship will find at page 53.
Yes.
Page 53, serial number 8.
Yes.
That is the, my lord, pension account, my lord. But they say it's a savings.
No, this is savings account.
This is my pension account, my lord.
And what about like the FD, savings? How many accounts you have?
My lord, accounts of mine, my daughter, my wife, my lord.
No. Ajay Kumar Das.
Yes.
All savings. How many accounts you maintain?
My lord, these are accounts of various other dates, different other times, my lord. And the lordship will see at page 54 my wife's. And she was an advisor to my lord, Birla Sun Life, my lord.
Yes, who is appealing?
Yes, ma'am.
Yes.
The preliminary objection is that the writ application is that the authority to application is not maintainable because they have already approved previously and there is no change of circumstance so that he will file an application before it. That is my in support of that. I have given a decision. Bishamlal Burma case.
Right.
Sorry.
Against the attachment order, what is the remedy?
But the specific provision is there
Yes, so.
that up, yes. Section 5.
Yes.
Well, 5B.
B5.
B. Such proceeds of crime
Huh.
are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceeding relating to confiscation of such proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days. This provisional order of attachment will continue for 180 days. And in the meanwhile, there is provision because the opportunity is given, will be given to the other side, to affected parties, provided, my lord, yes, sir. Thereafter, my lord, 5 clause 5.
5.
Yes, ma'am. The director or any other officer. So 5. Who provisionally attaches any property under subsection 1 shall within a period of 30 days from such attachment file a complaint stating the facts of such attachment before the adjudicating authority. Well, the attachment is a civil proceeding, not a criminal proceeding. We have not filed any case against him. It is relating to attachment. In case of attachment, also parties who are agreed by the attachment can contest this case. It is a purely civil case, that Madanlal Chaudhary case. Attachment proceeding is a civil proceeding. When complaint will be filed against him before the special court, then there is a criminal jurisdiction. So now at present,
It is only at the stage of attachment, so therefore you say that it is a civil proceeding, no 482 lies.
no problem.
Unless the adjudication proceeding is initiated against him.
Yes.
482 is not maintained.
Yes,
That's true.
because provisional attachment will be subject to confirmation of by the higher authority.
Adjudicating authority.
So for purpose of confirmation, opportunity is given to him.
Show me the provisional attachment is a civil proceeding.
Yes.
Show me the judgment. But how can you attach the pension account and all?
That is why law says you have to produce the documents before the adjudicating authority. Now it is not adjudicated. Prima facie, some property has been attached provisionally. It will continue for only 180 days. Subject to condition, if it will be confirmed by the adjudicating authority and the opportunity will be given, he will produce all the documents. He may modify the provisional attachment. So now, since the alternative remedy is there, this application is not maintained.
Show me the judgment.
But before that, Lordship may kindly see for section
No,
5.
this is the point you have to deal with.
Yes, that is what exactly I'm saying, my lord.
Right.
Not subsection B proviso.
Subsection B proviso.
Yes.
Yes.
That no such order of attachment shall be made unless, in relation to the scheduled offence, a report has been forwarded to a magistrate under section 173 CRPC, or a complaint has been filed by a person authorized to investigate an offence mentioned in that schedule before a magistrate, or a court taking cognizance of the scheduled offence, as the case may be, or a similar report or complaint has been made or filed under the corresponding law for the time being in any other country. So
again, it is a provisional attachment.
But then I am saying, my lord,
If there is a bar, a provisional attachment, thereafter it will be subjected to an adjudicating process. There you can raise all these points.
Lordship may just see thereafter, my lord.
Yes.
Provide, my lord, what is the, my lord, charging section here? It is 5(1)(b).
B, right.
But Lord, that is what is the main provision that controls, my lord, the provisos, my lord.
No, what he says is 5(1)(b) is the provisional attachment order.
No, I'm sorry.
Subject to 5(5).
I'm sorry, my lord, that's not correct.
5(5) is completed.
Yes.
Then you have a cause of action to maintain 482. That's what he says.
No, I am coming to that, my lord.
Yes.
Lordship will kindly see their order itself.
Yes.
My lord, at page 26.
Yes.
Provisional attachment under subsection 1 of section 5.
1B.
So I'm coming that, my lord. So it is section
1B, but
so it's 5(1). So
5(5).
no,
5(5).
But they have exercised 5(1). They have exercised 5(1), my lord. It is not under 5(5).
When the
before 5(1).
when the provisional attachment order was passed?
My lord, it is 23rd, my lord.
23rd of
this month, my lord.
This
February.
30 days thereafter, within 30 days, they will resort to 5(5).
But so that is why
then you get.
But then, of course, now I am saying, my lord, it is 5. What my learned friend is saying, when it is an
he says that it's not maintainable. Go with that judgment.
Yes. 177. Please.
So wait till 5(5) is.
Lordship may just see, my lord. It is only with again, my lord, if it is with regard to the proceeds of the crime.
In the provisional attachment says.
My lord, it has to be with regard to the proceeds of the crime, my lord.
Where are you reading, sir? This
177.
170.
Para 177.
Read it out.
Yes, ma'am.
Suffice it to observe.
Yes, ma'am.
You have a copy.
Because it is a big judgment about 500 pages.
We are 3 people. You, me, and.
It's the initial stage of admission.
Suffice it to observe that being a specialist in providing. This is a judgment.
Judgment, yes. Entirely one judgment. Madanlal Chaudhary judgment. Different sections, provisions are challenged.
The mechanism and inquiry investigation of the proceeding against the property being treated crime under this act by way of civil action, attachment and confiscation. Formalization. You just show it, show the judgment. Show it. Show it to him.
Yes, sir. Sure, please.
Yes.
I'm getting it right now.
When are you resorting to 5-5?
Yes, already
Initiate.
because now within 30 days you have to file the case there, have to take instruction that. But thing is that now
Yes.
sufficient opportunity given to him in view of the provision of section 8 proviso, provided that if the property is claimed by a person other than a person to whom the notice had been issued, such person shall also be given an opportunity. So now he can place his all claims before the adjudicating authority, it will be decided. Thereafter, after confirmation,
Nay, looking into the peculiar facts of this case, can the 482 court at this stage can direct the director, adjudicating officer, to expedite it and fix the time?
there is no case now.
Now, you would be doing it
Provided it will be filed before the
subject to file, of course.
My lord, Lordship may kindly read what para 177 with me, my lord.
Well, there is a provision also. Adjudicating authority has to decide in a certain period.
Where is that?
Sir,
Where is that?
Sir, judgment is
It's already there. There must be there.
Yes.
It is already there.
Lordship may kindly read it with me, my lord.
Yeah, just see what is the scheme of it. Where is the time frame given to adjudicating? 8, section 8.
Section 8.
Come to section 8. Timeline is given.
The timeline is 6 months, my lord.
30, within 30 days.
30 days we have to file, communicate. Then within 180 days, the adjudicating authority has to decide.
Yes. Give 120. Yes.
But may I read,
Yes.
my lord? Suffice is to observe that being a special legislation providing for special mechanism regarding inquiry, investigation of offense of the money laundering, analogy cannot be drawn from the provisions of 1973 code in regard to registration of offense of money laundering, and more so being a complaint procedure prescribed under the 202 Act. Now let me pause here for a moment. So here, the first thing is that the registration of a money laundering case, that happens 44(1), my lord. Not happened as yet. It is further, the authorities referred to in section 48 of the 2002 Act.
44(1) you have initiated against the...
No, my lord.
41.
44(1).
There is no, now that is not the time.
It is.
Because I saw one of the orders which says that...
But let me read it again, my lord. It is a different matter that the materials...
Yes, now court is asking. Now provisional attachment is subject to finalization by the adjudicating authority. Now time has not come. He is to now place all the matters before the adjudicating authority. Before that, he is avoiding to appear there. That means...
Further,
Well, it is absolutely preposterous to say I'm avoiding to avoid.
Can you tell me when 5-5 when are you resorting to? Whether you see it is a provisional attachment order will remain enforceable enforced for 180 days only. 180 days. Thereafter it automatically left if you don't resort to 5-5. Automatically left.
After 5-1, my lord, immediately within 30 days under 5-5 we have to file before that.
It is not necessary. You have to. You may choose not to do it.
No, my lord. We have to. Because it's a provisional attachment order. We have to file before the adjudicating authority, my lord.
Shall within it.
Yes. So we have to. Adjudicating authority will issue notice and he has to decide within 180 days.
Yes. That's the scheme.
180 days, the adjudicating authority has to decide. Then, my lord, against adjudicating authority order, under 26 appeal is provided to the appellate tribunal. my lord. Then second appeal to this
I know,
honorable court under section.
See, I am interfering at this stage in serving the jurisdiction of adjudicating authority.
Now,
I
this
can't do
honorable
that.
court, this honorable court is the second appellate authority, so that this
I-
attachment is done.
Yes, Mr. Das, that's the whole difficulty with you.
My lord, there is no,
Today you are
there is
asking
no,
me to exercise the
No, no, no,
jurisdiction
my lord.
of adjudicating authority.
no, my lord.
Whether this is right
My lord,
or
I'm not saying that, my lord. With attachment of the proceeds of the crime, my lord, if
that will be looked into by the
Well,
adjudicating authority.
then, well, when I am showing me that the pension is not the proceeds of the crime.
That's whether that is the reason the so-called notice will be given. You have to tell the
Well,
adjudicating authority.
well,
It can't be.
there is no straightway attachment. There is no show cause. It is straightway attachment.
All these
No,
things.
no. Section 50 procedure.
All these things. The
Well,
adjudicating
well,
authority can only.
well, he is saying no, no, no. Let him say my pension has not been attached.
A pension
Can
is
he-
attached. I've seen it. Pension is attached.
Well, how can he say no, 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 my lord? My pension is attached, my lord. So I don't know. My first of all, my lord, the entire assets have been attached.
That's right.
The pension has been attached. How will a person leave, my lord?
Whether rightly attached or wrongly attached, the only adjudicating authority.
My
can
lord, the
do
only thing, my lord, it is prima facie, which is apparent, my lord. It is apparent that the pension under no
I was just thinking loud that whether
Lordship, kindly say, my lord. Lordship,
time
kindly-
frame direction to the
I
that
agree,
also
my lord.
not possible.
What I'm saying, my lord, no, but as was being done in the previous case, your lordship was just reading out the FIR. And for something, the vehicle is not giving me the mileage, and something for that is in the criminal case. Well, the way it is absolutely absurd. In the similar fashion, my lord, this is absolutely absurd, my lord.
You tell me, Mr. Agarwal, you tell me whether the pension account which has been provisionally attached
Yes.
Can be released by this court or not. Only that.
Yes, exactly.
That, my friend, is to take instruction.
You have to take.
Yes.
That you have to
This
take.
is vagrancy, you know. Somebody's survival is a question.
That's true.
You can't attach because that can't no stretch of imagination you can say that it's a sale procedure.
That your lordship may grant some short time, my lord. That
Tuesday to 3 o'clock.
Which account, my lord?
That is one
That's
pension
account
account. You think over how can you attach pension account provisionally? You can't.
But if it actually
It
is
is
a pension account,
apparently, you know, 482 court can go into all these things.
my lord,
At
if-
least.
provided it is a pension account,
Yes, that's what
and the pension amount is available.
Your
Yes,
lordship
yes,
may
exactly.
call it
The
Whatever.
excess
See,
amount.
what you attach it, his pension will be deposited that he can't get the pension. How will he survive?
your lordship may call it tomorrow or day after tomorrow.
Next week. my lord. Because
Tomorrow day after means a holiday.
Okay. And next week, your lordship may say,
Tuesday at 3 o'clock.
In the meanwhile,
Wednesday at 3 o'clock.
yes.
You come with me.
Yes.
And you, which are, see, if a reasonable thing you do, no problem under the
Yes,
provisions
yes,
of law. If it is not sale proceed at all from the face of it, you can see how can you attach.
Yes.
That part you have to just see.
Provided he has made out a case in that.
That's right.
Yes.
But can be 11th, my lord. But 12th, 13th, 14th, my lord, that from 12th, my lord, I'm going out, my lord.
11th,
No,
11th and 12th,
My lord, 11th, my lord, at 3 o'clock.
all bail matters, that's the whole difficulty. 11th, I am,
My lord, well, I just want.
I am also traveling. So that's the reason.
No, so there will be problem for
15th, 16th, whenever you want.
15th, 14th, 15th, I'm out of the town, my lord.
Let us make 15th. No.
15th. No.
No.
18th at 3 o'clock.
18th.
बादल पटना VCC appeal है जी. Well, my lord, 30th, my lord.
13th.
Yes.
30th.
And
To
I
that
can.
extent, you just tell me
Yes.
so that I can interfere in this stage, and then 5 will take its own course.
My lord, the entire.
Examine every asset provisionally you have attached, which is not relatable to the sale proceeds.
My lord, the only. My
If
lord,
a doubtful thing, one can adjudicating authority can only do,
yes.
which are doubtful.
regarding pension account, my lords are right. How they have that we have to take it. Otherwise, my lord, certain time what happens, my lord, suppose I committed a schedule offense. to hide the proceeds of crime, I keep that money to wife. So he said that this is the,
look at the number of
there are
accounts here.
two types of accused, my lord, under PMLA. One, the person who has committed a schedule offense. The other, who has treated that proceeds of crime as
I know.
So there are two types. So in certain
All Benami transactions
yes,
are all.
so certain times what happens, my lord, a person who has not committed the schedule offense, the money is part with the other person. So he is to be also included, that property is to be included and attached. For that, my lord, subsection 3 has been amended, my lord.
Now, what is the situation? Suppose you say 3 crore DA. 3 crore DA, but you attach the property which is much more
No,
beyond 3 crores.
That we can do, my lord. Why, my lord? What happens, my lord? Suppose vigilance department has to only investigate during check period.
Okay, I understand. It may be.
Your lordship, yes, my lord.
Yes.
Well, here, my lord, one thing
Because
is.
that amount has no meaning. In
Amount has-
PMLA,
yes.
It's a wider.
What is the proceeds of
No,
crime?
that is exactly, that is what I wanted to point out, my lord. The check period is the entire service period. The entire service period, the check period, my lord, here. And after the service period, it's only the pension. If the authority under the PMLA can bring out any document that after the retirement some property has been acquired and the acquisition is a proceeds of the crime, then it can be seized. So lordship has right to put the question.
Imagine a situation, you have from the sale, the crime proceed, you have purchased one property for 2 crore. You sold it for 5 crores.
That will
Then after you kept on
that will
selling
be
it
included.
for 100 crores.
Correct. No, that will be
Then
included.
that is relatable to sale
No,
proceeds, so the entire thing goes.
I totally bow down. That will be included. But there has to be a material to that extent.
Keep on doing business even after
It is-
retirement.
Person in possession, my lord.
Well, yes, that has to be, there has to be positive material for their satisfaction. Yes, it has been done.
That is why the scheme is adjudicating authority will look into it.
And that is the reason, my lord, I submit, my lord, Section 2, subsection 38 of the my lord, General Process Act, read with Section 46 of the General Process Act, my lord. It is always, my lord, an offense committed. The law which is prevalent at the time of commission of the offense, if that property which they in their language, it is, my lord, the proceeds of the crime, does not get multiplied subsequently, then do they have the jurisdiction? They cannot. Lord, then Article 20, sub-article 1, and Article 20, sub-article 2 of the Constitution states at them. No, answer not in the facts of this kind. Sorry, I've gone through the entire judgment.
Facts of this case maybe, but it can be.
Yes, can be.
It
Can be, which your lordship said.
Article 20 cannot be.
Of course.
No. This issue has been raised
again,
in Vijay Madan Lal.
What I'm saying,
Honorable Apex Court has decided this. I agree. Sir,
Lord, what your lordship said, that is the most appropriate thing, my lord. As proceeds of a crime ultimately getting multiplied, that also becomes a proceeds of the crime.
Right.
If a proceed, then Article 20 will not come into play. If the proceeds of the crime does not get multiplied.
If the proceeds of the crime, you invest in a business.
Yes.
You earn money, the
Agreed,
entire thing goes.
Agreed, my lord.
Article 20 will not apply.
Another
because he
situation
is not
will-
accused. So far the attachment is concerned, he is not accused.
But you, every attachment, the property which are now confiscated, just check it, which can be excluded.
Yes.
Confiscation, my lord, is not the confiscation will be done by the special court.
Yes.
While deciding the complaint.
Provisional attachment.
No, confiscation is not.
Not confiscation. Provisional.
Lordship may kindly see again, when there is a vigilance case pending, my lord, the confiscation against under the Special Courts Act will be by the authorized officer. Under the Special Courts Act.
Right.
Chapter 3, my lord. Now, confiscation by one and here confiscation by another. There are lot many things we gone into. It can't be said.
And you can read that Special Court Act also, the validity was challenged.
Yes, exactly. And upheld. It was upheld.
Here what happened?
I happen to be
Yes, exactly, my lord.
The vigilance matter, both will be tried by the special court, and the special court will confiscate the property.
Right.
This attachment order will prevail over the attachment made by the vigilance department below.
But certainly the attachment cannot be made to, my lord, overreach the orders of the court.
No.
Yes. Obviously.
Exactly, my lord. It has been done
can
so.
be done overreaching the court.
Exactly, it has been done so, my lord.
Let us see.
Yes.
13. Okay. Yes.
11. May I please, lordships?
So,
The
order taking cognizance is under challenge. So also the entire, I've sought for quashing of the entire criminal proceedings.
Yes.
The FIR as well as the entire the charge sheet, it has been based upon an internal audit report and a special audit report. And the audit was conducted in relation of utilization of our autonomous college for the accounting years 2013-14. Continued as principal January 2016.
Yes.
I have annexed the copy of both the internal reports, audit reports. Now, your lordship may kindly come to page.
What is the stage?
Stage, my lord, they have submitted the charge sheet. Cognizance has been taken and it is pending, posted for supply of PP. It's pending.
Another application is serial elements number 493 of
That is filed by another co-accused, one Keshav Chandra Khuntia. That is not filed by me.
Whatever,
but
that's
It's not filed by
that
me.
may be taken off LM with this member.
More saying that there is concern nahi.
Nahi
That-
kyunki Siba se one of the
He is also challenging the
No,
cognizance.
that was,
One of the
I have
package-
verified. And it's a challenge Korithiba cognizance order, but I have verified from the website.
Arising out of the same
That
FIR.
was dismissed for non-prosecution. I have not seen the ground of challenge, what he has, what was the ground? Your lordship may kindly hear me, please. My first ground of challenge is the internal audit report, the internal audit as well as the special audit, both have been reviewed and approved by the district audit officers and with same audit superintendent. Now, your lordship may kindly come to page 46. The first internal audit report exonerates me. Page 46.
46, okay. Yes.
Your lordship may kindly see 11.1.
One.
No misappropriation is detected during the period of
1
audit.
minute, sir, 1 minute.
My lords.
40?
Page 46 of the brief.
Yes, 46. 48. 46. Yes, 46.
This is it begins from page 24, annexure 2. Page 46, your lordship says, this is so far as I am concerned, this present petitioner is concerned. The internal audit says, no misappropriation is detected during the period of audit. Now, your lordship may kindly come back to page 24. The period of audit
Yes.
and
Period of audit.
page 24, if your lordship sees, the reviewing officer and the district audit officer at serial number 6 and 10, Sudhanshu Sekhar Mahanti and Prafulla Kumar Behra.
Who are you?
They were the reviewing officers and the approving officers.
Who are
Who
you?
have,
Let us see.
I am my lord Saurabh Das. Same page 24, item number 3. The petitioner is Saurabh Das before your lordships. My period, I continued as principal from 1st of March
But
2000.
this is only cognizance. In the charge sheet, you should argue all these things.
No, again, your lordship knows because there are decisions. I have also filed a copy of that decision in support of my contention that if the entire case is based upon an audit report, conviction and this commission of this, because it is no conclusive proof of these offences. Your lordship, I have also annexed, filed by way of a memo that Hemanta Patra decision. Similar matter, my lords. That was also a case where the FIR and the charge sheet was solely based upon an audit report and not a single.
What is the extent of misappropriation according to FIR?
This particular case, so far as I am involved, it is 14 lakh some odd. Now, in the meantime, they say it is 613 rupees. I have also annexed. So far as the audit is concerned, audit ta again 14 lakh ru sidha asi jaichi 613 tonka. And my ground of other grounds of challenge is the informant himself, being the local authority, furnished all the explanations and the informations basing upon which the special audit report has been prepared.
You were working as what?
I was the principal for a given term.
Ex-principal.
Ex-principal. And this Hemanta Kumar, this informant, Hemanta Kumar Raut, he was my subsequent successor. He was successor. And he says, and the entire case is the special audit report upon which this FIR and the charge sheet has been submitted. The entire objection has been filed and furnished by the informant only, and withholding my objection. I have annexed. Your lordship may kindly come to page 142. Only I'll take 1 minute, my lords. Prima facie, I am satisfying your lordship.
Now, where is the citation you want?
Citation I have given my lord Hemanta Kumar Patra.
Read it.
My lords.
Which para?
That was a case before taking your lordships to the paragraph 5 is the relevant paragraph, series of decisions of this honorable court.
Come. Question as to whether.
But again,
An audit report.
the question as to whether an audit report can be considered to be of conclusive nature and without any evidence can form the basis of conviction has come up before this court in various cases. In the case of State of Odisha versus Chamara Ponda 1985 CLR 308, this court categorically laid down that an audit report of an inconclusive character which notes down some statements of objection cannot by itself saddle any person with criminal liability.
Okay.
In the case of so and so.
Wait. Yes, Mr. Maharaj.
Yes, my lord. But the sum total of the cases that, my lord, at the time charge sheet has been filed against Akshay Kumar Mahanti, Vidyadhar Saul, Keshav Chandra Khuntia, and Saurabh Kumar Das. In the meantime, Akshay Kumar Mahanti and Keshav Chandra Khuntia, sorry, Akshay Kumar Mahanti and Vidyadhar Saul, they have already expired, leaving behind two accused persons. It's a case of where 1 crore 43 lakhs 17,100
basis of the FIR is the audit report.
Audit report. That I am coming to that. And now leftover who are left? The Keshav Chandra Khuntia and Saurabh Das. So Keshav Chandra Khuntia is not yet been arrested. He is absconding. Now Keshav Chandra, the Saurabh Kumar Das is left. So far the audit report as annexed by my friend, I have find out that some of the record it shows that whatever document is annexed, I found some sort of disturbance is there in the audit report. And as he has stated also, 6,000 something has been it yet to be recovered from the petitioner. From the petitioner. So entire thing, this is not the stage to scrutinize all the documents to my submission, my lord. And it can be raised at this time of removal charge. Only 2 persons are left. One is absconding. It's a case of 1 crore 43 lakhs 7,715 rupees. So it is to be established at the time of trial, my lord. Let the charge be framed at the time. Raise all the point. But this is not the stage.
Judgment is also you are relying upon.
That is a case of under section 482. That's a reported decision of this honorable court. That is a case.
What was the stage?
Again,
What case has been taken?
Again, Hemanta Patra case, if a lordship says the facts of that case is that that petitioner was working as a branch postmaster.
Yes.
And the FIR and the charge sheet was submitted solely based upon an audit report.
Yes.
And your lordship says, I am taking your lordships to paragraph 3 of that decision.
Yes.
Seta be 482.
Yes, Seta, collective responsibility.
First paragraph.
Again.
This is the
and in paragraph 3,
in paragraph 3, responsibility.
Paragraph 3.
These are the persons, those have been given the responsibility.
What?
My lord, there are 4 grounds, my lord. Prima facie, I am satisfying your lordships. First ground is their audit report, because save and accept 2 audit reports, the investigating officer has not seized any other document. Only it is based upon internal audit report and special audit report. So far as the internal audit report, I have prima facie pointed out before lordships that they themselves say that no misappropriation has detected.
Internal audit and final audit.
My lords?
Internal audit and final audit report.
Again, data audit achi. Internal audit and special audit. Internal audit, if your lordship says that has been reviewed.
What are the other evidences?
Other grounds of challenge, my lord.
Evidences collected by the police.
Kichi nahi hai kya? Khali audit. Aur kichi nahi. Let them show any other scrap of paper. Excepting audit, there is none.
That is the charge sheet. Your lordship can turn to page 120.
Directly covered by this judgment. Whole difficulty.
No, judgment is there. I don't dispute that.
Then
question is,
I have filed the special
seizure judgment straight away. That is also cognizance of
nobody is left, my lord. Those are liabilities, the collective responsibility.
I have annexed the entire charge sheet, as well as the seizure list.
We will examine. We issue notice to the opposite party, Mr. Maharaja accept notice for this thing. And I am staying the process.
Once your lordship will stay, then the further proceeding will not continue, because one of the accused whose application filed before the honorable court has been disposed of. 490
that has been dismissed for non-prosecution.
Let him move application and it will be urgent till I decide, because he is covered by this judgment. How to get out of it?
Your lordship may fix a date. Any short date. Any short date.
I am fixing a date. Fix a date. Reasonable to insofar as the IA is concerned. Learned counsel for the petitioner submits that he would be moving appropriate applications for adjournment before the court below, owing to the fact that the matter is pending sub judice before this court. If such application is moved, the trial court may favorably consider the same. Because he is directly covered. How will you get out of it? If you have any other document except the special audit and internal audit, you show me. If special audit, internal audit is there, that is the only basis of your charge sheet. Then this is directly covered by this judgment, and I'll pass.
And he has not totally covered. He has not totally covered because you are not totally exonerated from the charges. Some discrepancies is there that has also been mentioned. 600 will be accepting.
No misappropriation. That is the indication at page 42.
Yes, that is there. But
then why should he suffer the
entire documents is not there with the.
You check it up. If this is the only two document on the basis of your entire prosecution is
Let them also check up another point that at page 142, I have annexed that copy. The informant in this present case, the special audit has been prepared only considering the explanations furnished by him, and he deliberately has withdrawn my objections. So,
let him examine.
Which is why subsequently the spot verification was conducted, and I have been exonerated from dropping all the earlier charges.
We'll see. You are directly covered by this. Okay. Yes.
Lords may fix a date.
Date is fixed.
Obliged.
Here, my lord, I have challenged the discharge rejection of the discharge petition, my lord, by Minister 5. In this case, my lord, the background of the case is that the petitioner was charge sheeted under section 376 2N and 417, and the petitioner has challenged the cognizance order. Your lordship has discharge the petition so far to 376 2N is concerned. Subsequently, the 300 so far the 417 and moved for discharge petition. Under some 439 that was rejected. The whole case is that there is a relationship, love relationship between the petitioner and the victim for 7 years. And out of the relationship, a child was born. And subsequently, when the marriage was not fructified as per the promise, he has filed a 376 2N case and 470. In that event, the court has said if there is no initial any intention to
so 164 statement.
164 statement is not with me. 161.
Yes, not annexed the 164. Not annexed 164. Page 8, page 28. 161 statement of
161 I have understood.
Mona Lisa Pradhan.
161 lordship I have me read. Page 28 lordship. ମୋ ନାମ ମୋନାଲିସା ପ୍ରଧାନ 30 ବର୍ଷ ସ୍ୱର୍ଗତ ରବୀନ୍ଦ୍ର ପ୍ରଧାନ ଆଜି ତା 14/7/2021 ରାଇକିଆ ଥାନାରେ ଉପରୋକ୍ତ ମକରଦାମ ସଂକ୍ରାନ୍ତିରେ ରାଇକିଆ ଥାନା ଏସ୍ଆଇ ବାବୁଙ୍କୁ ଦେବା ମୋର ମୌଖିକ ବୟାନ ନେଇକି ଯେ ଗତ ପ୍ରାୟ 7 ବର୍ଷ ତଳେ ମୋତେ ବାହା ହେବା ନିମନ୍ତେ ଉଦୟଗିରିର ଅମରଜିତ ପ୍ରଧାନ ଓ ତା ସାଙ୍ଗ ଜଣେ ମିଶି ଆମ ଘର କାଳୁମୁହାରକୁ ଆସି ଆମ ଘରେ ମୋ ମାଆକୁ ପ୍ରସ୍ତାବ ଦେଇ ସେଇଦିନ ମୋ ମା ମୀରା ପ୍ରଧାନ ତାଙ୍କୁ କହିଲେ ଯେ ତୁମ ବାପା ମାଆଙ୍କୁ ଧରି ଆସିଲେ ଆମ ଘରକୁ ଆସ ଆମେ ରାଜି ହେଲେ ଆମେ ଆଗକୁ କଥା ବଢାଇବା। ଏହା ଶୁଣି ଅମରଜିତ କହିଲା ମୋର ବାପା ମାଆଙ୍କୁ ବୁଝା ସୁଝେଇ ବାହା କରିବାକୁ ରାଜି କରାଇବି। ସେଦିନ ସେ ପୁଅ ମୋ ସହିତ ଆମ ଘରେ କଥାବାର୍ତ୍ତା ହେଲା ମୋ ଠାରୁ ମୋର ମୋବାଇଲ ନମ୍ବର ମାଗି ନେଇଥିଲା। यार केते दिन पर पुओ घर तरफ कहले जे आम स्टाटस सहित तुम स्टाटस मिसिबो नै आ तुम पर अलग जाति आमे तुम झियो सहित आम पुअर बाहागर करिबो नै किंतु से पुओ आम घर को आसी मोर मां को कहला मु जेमिति हेले मोर बापू मां को बुझाई सुझाई तुम सहित तुम झियो सहित बाहा होबी किंतु मोर मां मना कले जे तुमर जदि बापू मां राजी होनांती तबे आम झियो सहित संपर्क रखिबो नै किंतु से पुओ राजी हला नै मु गत 2015-16 रे भुवनेश्वर कलिंग हॉस्पिटल स्टाफ नर्स चाकरी पाइले सेतबेले से पुओ भुवनेश्वर रसुलगढ़ जगन्नाथ कॉलोनी लेन 5 रे घर भड़ा नै ऑफिस करी रहउतला ता घर मध्य साना भाई सचिनजीत प्रधान और तार मामू भाई हनक दिगल मध्य ता स्त्री को धरी रहउतले भुवनेश्वर कलिंग मेडिकल चाकरी करी से मेडिकल हॉस्टल रहउताय मोर मेडिकल ड्यूटी सारी मु रेस्ट नेउथवा बेले से पुओ आम हॉस्टल को पाखक आसी मो सहित कथबार्ता करे आ पाखरे थिवा ग्रीन चिली रेस्टोरेंट को संगे नै संग होई खाइबा पीबा करू गत 2015 रु 2017 मसिया पर्यंत से पुओ मते 2 दिन सकासे तार घर रसुलगढ़ को मते नै रखुतला आ विवाह प्रतिश्रुति दे मो सहित शारीरिक संपर्क रखुतला गत 2017 मसिया रे से मते नै तार रहिबा घरे रसुलगढ़ जगन्नाथ कॉलोनी रे 5
2005 ରୁ 7-8 ମାସ ରଖିଲା। ମୁଁ ସେଠାରେ ରହିବା ବେଳେ ଆମେ ଦୁଇ ଜଣ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭାବରେ ଚଳୁଥିଲୁ। ସେଠାରେ ରହିବା ସମୟରେ ସେ ପୁଅ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ହୁଏ। 2017 ମସିହା ଅକ୍ଟୋବର ମାସରେ ଭୁବନେଶ୍ୱରର ଆପୋଲୋ ହସ୍ପିଟାଲରେ ଷ୍ଟାଫ ନର୍ସ ଚାକିରି କଲି ଆଉ ହଷ୍ଟେଲ ରହିଲି। ଏହାପରେ ସେ ପୁଅ ଅମରଜିତ ଭୁବନେଶ୍ୱର ରସୁଲଗଡ଼ ଘର ଛାଡ଼ି ଜି ଉଦୟଗିରିରେ ଆସି ରହିଲା। ଆଉ ବେଳେ ବେଳେ ଭୁବନେଶ୍ୱର ଯାଇ ମୋତେ ସାଙ୍ଗରେ ନେଇ ଲଜରେ ରଖି ମୋ ସହିତ ସବୁ ଶାରୀରିକ ସମ୍ପର୍କ ରଖୁଥିଲା। ଗତ 2021 ମସିହା ଏପ୍ରିଲ 5 ତାରିଖରେ ସେ ପୁଅ ଭୁବନେଶ୍ୱର ଆସି ମୋତେ ଧରି ଡିଡି ଘରେ 2 ଦିନ ରଖିଲା। ଡିଡି ଘରେ 2 ଦିନ ରଖିଲା। ଆଉ 7/4/2021 ଗୋଟେ ଦିନ ନିମନ୍ତେ ଲକ୍ଷ୍ମୀ ଗେଷ୍ଟ ହାଉସରେ ଆପୋଲୋ ହସ୍ପିଟାଲ ନିକଟରେ ନେଇ ରଖିଲା। ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲା। ମୁଁ ତାକୁ ବାହା ହେବା ପାଇଁ କହିବାରୁ ସେ ପୁଅ କହିଲା ଆମର ଯଦି ପିଲା ଛୁଆ ହୋଇଯିବେ ତାହେଲେ ଆମ ଘର ଲୋକେ ମାନି ରାଜି ହୋଇ ଆମ ବାହାଘର କରାଇଦେବେ। ଗତ ଜୁନ ମାସରେ ମୋର ୟୁରିନ ପରୀକ୍ଷା କରି ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ସେ ପୁଅ ମୋ ସହିତ ରଖି ଶାରୀରିକ ସମ୍ପର୍କ ଯୋଗୁଁ ମୁଁ ଗର୍ଭ ହୋଇଛି। ଏ ବିଷୟରେ ମୁଁ ଅମରଜିତକୁ ଜଣାଇଲି। ଶୁଣିବା ପରେ ମତେ କହିଲା ଯେ ଗର୍ଭ ନଷ୍ଟ କରିଦିଅ ଓ ସେ ମୋ ସହିତ କଥା
What are the charges now?
ମାନେ
What are the charges against?
charges 417 and 376(2)(n) and 376(2)(n) was your lordship has already discharged him. By finding your lordship, the judgment is that
Very.
your lordship.
Then 417 remain.
My lord. Page 53, your lordship. Page 53. Page 53, your lordship.
Yes.
Page 53 is the last person, your lordship. Yes. Last paragraph, your lordship. Page 63, paragraph 11, your lordship.
It's all right now that 63.
63, paragraph 11. Yes, the court is quite conscious of the predicament of the victim informant who is at the receiving end and even become pregnant. It is unfortunate that a relationship built on friendship or affinity towards each other with love and affection reached a tragic end. For having been a relationship and not culminating in marriage between the partners leads to a misery for both, and at times it is more difficult for the female partner to stay stable and meet the challenges of life. The court is not oblivious of the above ground realities, but at the same time, it cannot be unmindful of the fact that in case of breach of promise, which does not have any immediate relevance and nexus with the consent of the victim.
Okay, the 376(2)(n) gone.
Yes, madam.
Then
Here my point is that the entire founded on the 417 is founded on the 376(2)(n). There's no cheating. Cheating. How is cheating? If there is a consent between both the parties, a relationship happened, a child was born out of that. How can there is cheating, my lord? Your lordship, the very concession 376(2)(n) is that initial promise of marriage, there is no intention to cheat him. Initial promise of marriage, there is no intention to cheat him. Then the 376(2)(n) and section 90 IPC will come into play if the consent is not consent, if there is any misconception of fact. Here there is no misconception. Both knows that relationship. He is a nurse. She knows the relationship and ultimately the child was born. After the child was born, see, your lordship, subsequent, your lordship, if there is initial cheating at the time of the promise of the marriage, and subsequently, suppose that he could not keep his promise of marriage, then it cannot be guilt cannot be done.
What are the indicators?
That is in Supreme Court judgment in Pramod Surabhana case, Source Paskumar case. Both the judgment has been referred by this High Court. After the finding of the Hon'Ble Court dropping the 376(2)(n), what is the question of cheating in this?
At what stage you came to this court?
At the stage of cognizance, my lord. At the stage of cognizance. A charge sheet has been filed. The court has appreciated both the.
It's eventually asking for review of that judgment.
Your lordship?
You eventually asking for revision.
No, my lord. I have not gone for 417. I have gone to 376(2)(n). 376 you also quashed it. Once 376(2)(n) is quashed, what is the question of cheating?
That time, 417 could have also been quashed.
No, my lord. I have not gone for that because 376 is a vital man.
No, that judgment is very exhaustive.
Very clearly
Very
stated.
clear
Your lordship,
judgment. Any order I am going to pass will be tantamount to reviewing that order.
Reviewing that.
I will not do it.
My lord,
You came at stage of cognizance.
My lord.
The court by a very detailed judgment.
By very detailed judgment.
That by only 376(2)(n) is not made out.
My lord.
And in so far as the other offences are concerned, it is made out. And then you went and move an application.
So far the manner 376(2)(n) is concerned. Initially I have challenged that.
No.
Subsequently,
No, you can't.
I challenged it on the ground.
No, you can't come instantly.
The discharge petition, my lord, there is a different appreciation. Discharge petition, your lordship, here the question, your lordship, mere FIR contextual
judgment. Every point is taken care of by the court.
Every point.
Every point.
Your lordship,
a 10-page judgment gave relief.
Your lordship,
Partly And now you are coming for another
No,
installment.
my lord,
And also
my
my
case-
my
First
lords
installment you have
are
taken and second installment.
No, no, my lord, here the case is that.
For every charge you keep on coming.
No, my lord.
There are two
No, no,
provisions involved. For one provision, both the provision you
here,
here.
here
You
my
got relief once,
my
and
respective
now you are coming in second.
my respective submission is that here your lordship no 377 Pramod Suryavan case says that if there is no any intention at the time of the initial promise and subsequently there are breach of promise.
In the trial it will be seen.
My lord,
Right down.
so your lordship is
by the order dated. When is that order? Cognizance order?
Cognizance order, my lord, under 5 your lordship. Cognizance order, discharge petition.
No, cognizance order you tell me.
no discharge petition has been rejected.
I know, sir, but I need cognizance order.
Yes.
Date you tell me.
Congress data कौन है?
I am giving.
Right down. Criminal MC number 2974 of 2021 was filed by the petitioner. Petitioner challenging the cognizance order dated so whereby the court below had taken cognizance of the offence under section 417, 493, 276, 2N, 294, 534 IPs.
Yes.
And the coordinate bench by the detailed judgment dated 21/3/2017 partly allowed the petition. Inter alia dating agent para 11.
Para 11, yes.
Page 60. Para 11, page 60. Page 60. After having accepted the said judgment, the petitioner subsequently moved an application before the court below under section 239 CRPC in discharge insofar as the other charges, other offences are concerned. By the impugn order.
Sir, 5 years page 60.
By the impugn order dated
23/2/2024.
Now the court below has rejected the application moved by the petitioner under section 239 CRPC. The petitioner seeks indulgence of this court. Taking into consideration the fact that the petitioner has earlier approved this court and by a detailed order and argued all the pointers in minute detail. And the court having taken into consideration the entirety of the case have concluded that no prima facie case under section 276 2N is made out.
Yes.
Yes. Partly allowed the petition in favor of the petitioner. Therefore, I find no illegal infirmity in the order passed by the learned court below, rejecting the application 239 CRPC. Hence, no case is made out for interference. It is dismissed.
Lordship, in the order of the Honorable High Court, Your Lordship, I have only prayer for the
I have passed an order. You have other remedies, you know. Yes. Yes. Yeah, what is the thing? Belgium. Yes.
My Lord, Belgium matter, Your Lordship.
When you got bail?
I got bail on 21/4/2014.
21/4/2014. NBW is 27/2/23. 23. 5th April. How much before? Okay. 500. Yes. 40. Yes.
Here, my Lord, that
bail.
I prefer quashing of the proceeding. Offense is my Lord. No, not Belgium.
14, huh?
Yes, my Lord.
Okay. Yes.
And next one, page 7, the affair. The offense is 493, 294, and 4 DP Act. So the at page 9, the FIR allegation.
You are Hajwe?
Yes, my lord.
Yes.
On 16/4/2028, there is marriage at Arya Samaj Balangir. And subsequently, what Lord should say, I'm placing the FIR on 16/4/2028.
Investigation is on.
No, charge sheet already filed.
Where is the charge sheet?
Lord should say, I have annexed to page 12. Cognizance is taken and charge is also framed.
Charge sheet kahin?
No, right now, don't have copy.
Charge sheet cognizance order can test koribu. If you don't give the charge sheet, file the charge sheet.
Yes, let's keep it next week. Yes, next week, any day I'll file in the meantime.
Next week, board permit, then only. You lost your opportunity. You should have filed.
Yes.
See, if you challenge the cognizance
Yes,
order,
yes. No.
charge sheet is minimum.
Yes, no. Cognizance Kumar.
Yes.
Yes.
The cognizance has already been taken. Let us see the charge sheet.
Yes, let's keep it next week any day.
We will give it. No problem.
Yes.
Next.
Belgium, my lord. Yes. Released on 6/1/2007.
6/1/2007.
7.
The question is
17 NVW. 6/7/2017 is the
My lord.
NVW. When you got the bail?
6/1/2007.
6/1/2007.
And NBW issued on 6/7/2007.
How many of you were there? 1,000.
My.
Yes. 41.
You want prayed for adjournment, my lord.
Adjourn.
42.
Password.
44, my lord, I am in BC, my lord. My lord, the notice has not been served. As it has been served, the postal endorsement has stated that address is left without instruction.
Press notice you will take.
Yes, press
My
notice.
Take press notice.
interim order was there, my lord.
Interim order to continue.
It lawless, my lord.
44 na? Press notice. 45.
45 also adjournment, my lord.
Why today you are asking for adjournment?
Mr. Sahu is not there.
46.
Here, the notice has returned back. I will ascertain the present correct address prior to, because he is the police officer who has put the petitioner into trouble without having any jurisdiction. So I have implicated the party. So I will try to collect, otherwise.
Notice is not sufficient.
Not sufficient, it is returned with some endorsement.
What is that endorsement? Address he left. What is the endorsement?
But he is in fact a police officer. At
Police officer.
yeah, at that relevant time, he harassed me. Because I have made some.
He is working police officer. No,
Yes,
retired.
yes, no, he is working. So he must.
What is written?
I have implemented him in a private capacity.
Oh, no, this is what you are challenging?
Either my landlord can also.
That's what I'm wondering. It is a FIR, na? You are police officer. Why don't you see where is he?
He can know his whereabouts and serve the notice.
Serve the opposite party number 2 through the IIC. Which police station, sir?
Lord, his resident is a PS Chandanpur.
No,
But he must be moving around through
He will
through
set
discharge.
yeah. Bodochona, PS Jajpur, na? FIR is Jajpur.
No. FIR is at Jajpur.
Right. Let him.
Yes.
The IIC of that police station.
Exactly.
The IIC of Bodochona, PS Jajpur.
Yes.
I directed to serve the opposite party number 2,
Well,
who is stated to be a police officer.
ex-police officer of that police station.
Who is stated to be a police officer.
Well,
I will give an additional copy.
by Monday I will.
Yes. Mr. Mishra, Mr. Mishra undertakes to give a additional copy to Mr. Rahul for serving the opposite party member.
Entry order to continue.
Entry order to continue.
My lord, I may pardon, 43, my lord.
Pass over 2 o'clock. Yes.
47.
Yes, 47.
47.
Pass over.
48.
Pass over.
49.
49, my lord, I am for the respondent.
Yes.
The noting was there, the opposite party number was not there. But my lord, the case is that they have given a wrong address, name of my company. I am actually Porida and Sons.
Sir, may I call it for next week?
Again. Correct.
I have made my appearance, my lord.
But you have appeared. They will
My
correct
lord.
it next time.
Yeah.
Next.
Deeply.
Same.
Say line to delete.
Not through
Not touch adjacent.
Not through so the entire fight is for not only, and that not is missing.
This technicality, my lord, is creating a such a lot problem. Many facilities, but the problem is that previously, because they now suppose there is mistake. We have applied for certificate copy. It is not granted because there is mistake in the order. And because the previously what it was happening, we pointed out to the court used to correct it. But now if it is uploaded.
That is the drawback.
Yeah.
Is what to do, the operator.
That happens.
Once it is
And
uploaded.
once again it has to be listed.
Correct.
If I correct it, then it is very dangerous thing.
There are-
Certificate copy somebody will take and
Many advantages, but less disadvantages.
it's always there, we have to face it.
I say, I concede.
Cannot was there, cannot or could not or something. Not is missing. The entire fight is because of
Enter
not.
file for this only.
10 days back, and till today, the accused is not able to avail the benefit, which was it. And then different.
That's it. Disadvantage is there, advantage is also there. Not making not key type key type. Last line, right?
Has not committed any error.
In view of the above, it is clear that the office of Mr. Pradhan has not committed any error. Has not committed any. Has committed any. Has not. The para 5 of the order dated. There is a typo in the para 5 of the order dated 23/2/2024. And the last 2 lines shall read like this. In view of the above, it is clear that the office of Mr. Pradhan has not committed, highlight for the not committed any error by concealing the filing of the earlier petition. We replace that. Okay.
51.
51.
Item 51, I pray for on passive amendments.
For modification.
See, but yes, 52.
53, I pray for next week.
Adjourn.
54.
54, my lord. There is a noting that the notice which was served, it was unserved because due to shortage of postal stamp. My lord. So, my lord, again I will.
There must be some interim order.
No interim order, my lord.
Okay, you do it.
I filed a petition for recalling of 311 petition which was rejected.
It's all right, you.
I will serve again, my lord.
Yes, next.
55.
My lord, by Monday I will serve because today, by Monday I will
By
serve.
Monday,
Yes.
he will. You will file the additional court fee, whatever.
Yes, my lord.
Check it. Okay.
55.
My lord, item 55, this is an application for modification of the bail condition, my lord. The bail order is at Annexure 7, page 95, my lord.
95. Why don't you go to the same court?
We went to the same court. The court said this court cannot do it, my lord. Annexure 10 is that order, my lord.
10.
Annexure 10 is that order, my lords. If your lordship,
What is the condition?
my lord, the condition is at page 99, my lords.
99. What is this?
3 and 4, he
He
shall
shall furnish a cash security.
He no, my lords, 3 and 4, at 99 towards the last.
He shall surrender his passport.
Surrender his passport and shall not leave the country without its prior permission.
He shall appear before
So
the
he
court,
shall-
meet and eat a penny.
18.
What is this?
The last
This is condition 3 is there. What is
Yes, my lords. My lords, he is one of the biggest producer of Bengali movies in India, my lords, in the Eastern Circuit.
Eastern Circle, yes.
He has offices in Bangladesh, in Thailand, and other countries, my lords. So he, my lords, every time, twice he has taken passport, surrendered it in time. Every date he has appeared before the trial court. Every date, your lordships may inquire, my lords, every date he has appeared before the trial court. Nothing is happening, my lords, he only has to sign.
Whether there is a flight risk or not, that is.
My lords, there is no, every day he comes down and
He can
signs.
surrender his passport.
He was granted bail.
He was granted bail by the Supreme Court.
Without permission of the court. You can seek permission and go.
Yes, but I'll seek permission and go, my lords. And the passport may be given to me because what happens, my lords? Suppose I want to travel to UK,
Yes,
I'll have to apply a visa.
Mr.
Yes.
Dheer.
Your lordship, Mr. Naik is on his left.
He will keep the passport with him, and in any case, he has to ask for permission. He can't leave.
Your lordships,
Yes, Mr. Naik.
your lordships have to seek instructions in the matter and file a reply
What
also.
is this? See, what he says is that, see, condition number 3. He shall surrender his passport before this court and shall not leave the country without permission of the court. He has to take permission from the court, no doubt about it. Only what he says that let him have the passport with him.
My lords, otherwise, what is happening, my lords? Suppose I have to go to UK, then my lords, because the dates are fixed suddenly.
I understand the visa and so many things.
So the passport is necessary, and I have
Without leave of the court, he will not leave the country.
But your lordships, I want to put it on record by filing an affidavit so that nobody questions me. Let it be an affidavit, your lordship.
I'll file an affidavit
Monday
today itself.
Today.
No, I also want to file a reply. What is the hurry?
Hurry is because movies are getting shot without
director.
Without the director.
Without the producer.
Sarkar lose him there and he can be hero now. Milan sir.
Mr. RK,
Yeah, then when can you file the affidavit?
by tomorrow?
You file the affidavit, we will alter that small condition.
But your lordship, I want to file a reply. Let it come after 1 week.
You file reply, let him for the reason known to.
I'll have to take him along with me for the shooting, my lords.
18th, huh?
So, sir, this condition is on each and every.
No, you have some function you told me.
Yes, your lordship. My brother is getting
20th. He has one more matter in 20th.
20th, your lordship.
Yes, I kept one matter for you. That 20th.
My lords.
Meanwhile, you file affidavit.
Yes, and he shall appear before this court on each date of posting of this case, my lords. That also may be.
That date it can be decided, lordship. I'll file a reply.
That date it can be decided. I'll file an.
That amount is secured.
And lordships, my friend can also see the records. He has appeared on each and every date.
We'll alter it.
Yes.
He will also agree to that.
Yes.
But he has a right to file.
He's a fair person, my lords.
Yes, he should be fair.
Yes. Deeply obliged.
File the affidavit, huh?
Yes, well, we'll file an affidavit.
Yes. Land council for the petitioners. She's time to file an affidavit. File an additional affidavit. And Mr. Naik file this affidavit.
Your lordship, a free copy of the order may be provided for compliance today.
A free copy. Yes. Gratefully. For you. How many passports are there? Six. 5 bail and 11 meters. Call it will attend. How many meters are there? 5 minutes, na? Yes, call it, we will get it.
56, 28th month. 20.
56.
56.
May I please, your lordship? My senior is there, obviously.
Yes, Mr. Singh,
You're not audible.
you're not audible. Good that you are not audible because I can't hear otherwise also.
You have to unmute.
I think.
Adjourn it to a suitability.
Malada. Huh?
Because
I
today
think
it
he
may
has not unmuted.
Today it may not be possible. That's the reason. Today it may not be possible for hearing, so therefore I'm just giving a suitable date. Give a suitable date. Yes, next.
57.
Amara 57. 57, huh? 57. May I please, your lordship? Yeah.
You choose a date.
Well,
Choose a date. Because today it may not be possible. That's the reason. You choose which date. Who is opposing you?
It's a government. Informant is there, but the government has to oppose me. So, my informant will assist through government, but the government is to oppose me. My your lordship, may I pray for next week, my lord, if your lordship pleases, my lord.
Week.
आर सप्ताह टिके रहू
नहीं, make it on 20th or 21st.
My 20th, your lordship.
20th, हो? हाँ? एक period तो?
The interim order to continue.
Interim order.
My
Lord, there will be little more days. We have applied for certificate.
No, I have objection, my lord.
All right.
I have objection, my lord.
You never know
The
what
informant will not determine how it is to be done.
Lord, if
You have to
here,
assist to.
the whole point is that our 482
Whatever it is.
petitions of 7 years, 8 years of these things are pending, it is not listed for hearing. Luckily, because your lordship is assigned only court of 2023 and onwards,
Yes.
it is repeatedly
But
listed.
what I am trying to do is wherever there is an interim order, I want to finish it. Or otherwise I vacate things.
Lord, I don't.
If there is an interim order, I want to finish.
Lord,
I am ready, my lord.
I am not disputing anything. Lord, कथारे अछि सबो नियम को मानि गले प्रॉब्लम टा बहुत कम जे जहाँ नियम but it is rule is rule. The whole point is that previously once notice is issued it was going to the queue, but now the court is two different courts and assignment is somebody
That's
else.
good. That's good.
No, the assignment is two court. The hearing up to 22 is different court. There the so much of assignment is there. 482 petitions of 5 years, 7 years, and 8 years are not listed.
I know, because this assignment there is less.
Less this thing. So that the whole point is that previously, as per the High Court rules, it has been completely changed from last 2 to 3 decades.
Changed for good.
No, I mean, I'm not. Let us not. Let me not go to the argument. Please, please.
When may I take leave, my lord?
Yes, I'm also proceeding.
Yeah.
I'm also.
With your lordship's kind permission.
Yes,
They're all-
The
yes.
21, your lordship.
20th.
20.
50.
May I please, your lordship? This is a matter arising out of matrimonial dispute, your lordship. Here already
needs hearing.
Yes, my lord. My lord, I have filed the requisites, but in the noting it doesn't reflect that it has served or
Let's
not.
see. Service, awaiting service, adjourned. Awaiting service on.
My lord, kindly allow a date, otherwise it is not. Yes, my lord.
Next 60.
60, my lord, they have filed. I am petitioner. The opposite party has filed a interlocal application for vacation of stay. I have received on 1/3/2024. I may be allowed some time to file objection.
So 133 proceeding.
May,
No,
you also may
133.
159 item. My friend, please come. First application when it was heard, my friend stated before your lordship that it has been compromised settled. Only because of that notice was issued.
Right.
It is his duty to make the opposite party to appear before your lordship.
No, my lord, I have already filed the requisites. I have the
Why requisites? You have made the compromise. Then it amounts to not compromise.
Then it,
Dadabati, collecting of Dadabati.
my lord, but the affidavit has been filed.
Once
No,
stay
no,
is given.
settle or not?
Yes, my lord.
अच्छा
So
चल
bring
गया
in-
सुना थी.
Okay, I'll contact my lord.
What is
My
it?
lord, my lord, I have already filed the requisites to serve the
But it's
notice.
all right, but you, since you have settled the dispute,
Yes,
you
ma'am.
can very well bring him.
Yes,
Yes, my lord.
obviously.
With the order of the court, my lord. I
I'll
will bring
requisite, that's a different story.
Yes, my
But
lord.
next time you have to bring it.
Yes,
Otherwise,
my
I'll dismiss it.
Yes, my lord. I will
What
bring
is the
it.
use of keeping
Yes,
it
my lord.
pending?
I'll. Oh, bless me.
Yes, 60.
60, my lord, I may be allowed some time to file objection to them.
Yes,
So 133 proceeding that has been stayed by this honorable court. I appeared and I filed an vacation of stay application. If it will be hard on merit, it will be disposed over.
Hello, you have filed vacation.
I have filed myself.
I may be allowed some time
Yes.
to file an objection.
You file objection.
Your lordship may fix up a next week's any date because by virtue of interim order.
That is a small matter.
Yes, yes. Very small matter. It will be disposed of. Why?
Interim order कौन करियो?
Yes.
Main matter ही खत्म करियो.
Yes, 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 yes.
So interim order right wrong there is an interim order. Why
Exactly.
to अगर vacation पे जति समय सुनी में
आज्ञा
main matter सुनी
Main matter सुनी
get ready for main matter. Forget about your application.
Yes.
Okay.
Beg your pardon, your lordship, item number 56, please fix the date on 8 or 9 April 18. An entry order of letter.
ଗୋଟେ ମିଛ ସତ କହିକି ଏଠି ଗୋଟେ ଚଲେଇବି।
Cognizance was taken against me, and I appeared and filed an application under section 205, which was allowed. The accused lives in Delhi. He is the managing director of a company for which he has to move to several places for his business purpose. So he had filed an application of section 205, which was allowed. Subsequently, I filed an application for framing of charge in absence of the accused in presence of the counsel, since my application for 205 was present. And the accused was unable to attend on that date, particularly in the court, for which I filed an application. That since the accused is in Delhi, he could not attend in person. The advocate be allowed to be present on behalf of the accused for framing of charge, for which that petition was rejected and MBW has been issued against him.
Which is the order?
My lord, 12/4/2023, page 8, your lordship, page 7, your lordship.
When can you appear?
Your lordship, that is saying fix up a date.
Okay. Petitioner was on bail in the affirmation. Petitioner has been accused in FIR number 22. He was on bail. He moved an application under 205 CRPC, which was allowed. But on what is the date? On 5/4/2023, court insisted for appearance, physical appearance of the petitioner at the time of framing of charges. Since the petitioner was absent, NBW was issued. NBW is issued. On instruction, the counsel of petition submitted that his client would be appearing before the court on or before 5th of April 2024 and seek remedy available to him under law. And till then, the NBW issued against the petitioner. Execution of the NBW issued against the petitioner is stayed. Disposal. Kept in event. Kept in event and yes.
16.
Yes.
7 kilo of ganja, your lordship.
How much?
7 kg. 7 kg.
Granted.
Yes, investigation on.
Granted, investigation on. Granted. Okay.
Okay.
And you will cooperate with investigation and
Yes, yes, your lordship.
the same, right? Outsider or what?
No, no. Same area. Look.
Malord, 76 2M 294 506 Malord.
Charge sheet submitted by Lord 3762 and 294 506. I have unassessed 161 statement of the victim. A clear case of law of affairs, my lord.
Now what the CD is required? 164 statement.
Unassessed 2 page 8 in the
Can you
kindly.
just see 164 statement? What does he say?
Both were love to each other.
What was the age?
Yes, my lord, 19 years. Girl is 19 years, boy is 24 years.
Till then, in the what my learned friend has attached the annexure to the 161 statement, my lord. The lordship may kindly have a glance that.
My lord, I'll
listen. Not this recurrent Nuadina Rabindra Chalan Mata phone Kuritan Goruku. Look,
So I have served that certified copy of that.
You find it,
That's it. Kali Bonzela.
give it to him.
my lord, the only your lordship may kindly have a just glance. The 5th line of the rejection order, my lord.
Yes.
The
Yes, the accused had on previous occasion had
yes, my lord.
once taken away the victim, suspecting his involvement in the occurrence. The brother-in-law of the victim was referred in the information, mother investigation. So, was raised to the investigation was taken up. The investigation. The accused was arrested and taken into custody. So, earlier another petition was there.
Yes, my lord.
And another affair.
Yes, my lord.
That victim age is 22 years.
Hmm?
Victim age is 22 years.
161 and 164 also has already been recorded.
Where is
According to the rejection order.
164 you have.
No, my lord, this is first time.
See, the allegation appears to be, see, this victim girl, earlier also she had gone with this boy.
Yes.
Stayed there
Yes.
with her.
Yes.
And there was an FIR.
Yes, my lord.
What happened in that FIR? He was in bail.
First issue that not was that affair. That on second issue, that petitioner brother has that accused brother has lost that affair, and that petitioner that victim has that the investigation report when the victim complained her that 3 days that victim has come to that accused with a private
What you are saying, I am not able to understand. Half the sentence you are saying, throwing some paper to him.
Or as it
What
appears from
exactly you
the,
want to say? What is your case?
as it appears from the this forwarding report and CD is required because this is a case where a girl has been taken by the yes.
You don't file the document. You are throwing some paper to me. and-
CD required.
34.
That's right, but you have to make out a case. You are not sure about what you are saying. Call for CD. 164 statement you don't have. You have to file the document. Call for CD next week.
Yes.
Or 18. You are entitled for bail, but you are making your own case difficult.
He received that written that 164 on rejection order.
Let him. You can't bring every paper and throw here. Because this is online. I can't, even if you give a paper, I can't keep it.
Online.
Because there is no file with me. That's the difficulty. Try to appreciate. Anyway, next.
May I please your lordship, my lord? My lord, here offense is understood 20B2C, my lord. My vehicle was seized. There is no conscious possession of ganjas, my lord. 60 kg ganja is involved.
60.
60, my lord. And my vehicle was.
That is true, my lord, but in fact, my lord, this petition also, another vehicle also involved in another case, my lord. And he has been arrested that case and remanded this case, my lord.
That case we are doing.
2 cases, my lord.
How many vehicles you have?
My lord, I have
full-fledged business.
No, my lord. In the first case, there is no antecedent, and he has been enlarged by this honorable court, my lord. In first case. And thereafter, in this case, he was taken on remand, my lord.
37.
And in this case, my lord, my vehicle is involved. A PR comes out that the vehicle is mildly desired.
Who was driving?
Driver was driving. Driver has been arrested.
You are driver?
No, I was not the driver. The driver is.
How it has gone there?
It must have been given. My driver definitely must be my driver. My vehicle driver, my lord.
Driver confessed his guilty and have stated that as per direction of the owner, I have.
That is confession statement of
And
co-accused.
what else? What evidence extra beyond the confession? What you have?
The vehicle belongs to the
That is.
and simultaneously 2 vehicles, my lord, in the same day.
Both the vehicles belong to you.
In different police stations.
Different places, not at one place. Whether in that case.
Habitually doing this type of business, my lord, that after my 37 is back, and another thing, my 37 says that if there is likelihood that he will not commit similar type of offense in future, my lord. That is my case, my lord.
What happened in that case? He has got bail.
Saying that
He has been enlarged on bail.
Where is that?
In order.
Have you filed it?
That is the first case, my lord. This is the second.
Yes, final charge sheet was made 4/10/2023. He is inside the custody since, my lord, 6th May 2023, my lord. Almost 1 year.
6th
May 2023. 6th May 2023. It is now.
Since there is a repeated.
Any stringent condition may be imposed.
For that reason, my lord, if there is no likelihood that if religion will commit similar type of.
Sabu bail. ଏତେ ଜୋରରେ
ପ୍ରଥମେ ଯୋଉ ବେଲ ହେଲା ସେଠି ବି ସେୟା କରିଥିବ ନା
ଫାର୍ଷ୍ଟ କେସ୍ ମାନେ ଆକ୍ଚୁଆଲି ମୁଁ ଫ୍ୟାକ୍ଟଟା କହିଦଉଛି ଫାର୍ଷ୍ଟ କେସ୍ ହେଲା ବେଳକୁ ଏଇ କେସ୍ଟା ହେଇନଥିଲା ସୋ ଦ୍ୟାଟ୍ ହି ଗଟ୍ ଦ ବେଲ୍ କମ୍ଫର୍ଟେବଲି ଦେୟାର ଆଣ୍ଡ ହିୟର ମାଇ ଲର୍ଡ
ସେତେବେଳକୁ 37 ବାର ନଥିଲା ନା
ଏବେ ବାର ଆସିଗଲା obviously my lord and when my lord 37 my lord was pleased to grant me the bail at the risk
do you
of
have any judgment to support you
pardon my lord
do you have any judgment to support
my lord I have my lord it is my lord subject to my lord's acceptance Here, my lord, in this case, whether I have been involved or not, it will be
That's right.
at the time of trial. The first case, since I was in conscious possession, I cannot deny the impact. So, my lord, my humble prayer before Lordship, because at the discretion of the court, I am getting the bail. And it is not that at the risk of the court also. It is my submission and my clients.
That
2%
No, it's a law. It's a law.
Yes,
We are not giving the, not opposing the bill. It's a law. 54 you also kindly see. Section 50.
I know that.
Actually, what has happened, my lord? I was on that side for 10 years. They are taking revenge now.
No,
Let us keep it on 18th. 18th.
18th, my lord.
You get
There are some decisions are there.
you get some decision.
Yes, my lord.
I'll grant bail, but to support that.
Yes, my lord. I will try.
Get some judgment.
Very difficult to get actually. I know, sure, sir. If I had difficult,
See,
always course is.
That is since about 1 year.
Yes, my lord.
Custody is
Exactly. That will be the only thing.
And
my
your
lord.
conscious position was not there.
Not there.
You are the owner. You are not in the spot also.
Yes, my lord.
So therefore, taking that as a clue, you can very well go.
But two things are there.
And 60 kilo, not.
Yes,
More than commercial content, another second. That is
He has to overcome these two.
Same day. My lord, the occurrence was same day. Both the things.
Okay, you overcome these two difficulty.
I cannot be unfair with this.
I think 18th would be a.
18. Oh, bless man.
18. CD. 302 CD.
My lord, may I pray, my lord? May I pray prior to that, because in the meantime, if something will happen, my lord, composition will be changed. My lord, I have a small prayer, my lord.
Don't worry, nothing will happen. Don't worry.
Oh, bless my lord.
42 may kindly be taken 1 week after.
Yes, 1 week.
What that the problem. All the anticipated matter, listed matter, NDPS matters. Earlier they are taking time. Which it means. Since you are thinking all the matters.
This is a part of game what to do.
Yes, yes.
Yes. Yes. 43.
My lord, the petitioner challenged the order under Annexure 6, my lord, on where the
43.
my lord, the petitioner filed the petition under section 227 of the CRPC with a prayer to discharge him from the charges under section 363 and 366 of IPC, my lord. But the long trial court has discharged only 363 of IPC and framed charges under section 365 and 366 of IPC, my lord. My lord, the fact of the case, my lord, the petitioner and the victim, on their own accord, they have fled away from the village and got married each other. And after recovery, my lord, see
164, just see, read the 164.
64, my lord. That is the running page is 18, my lord. Relevant person. ମୁଁ କୁନି ପଟ୍ଟନାୟକ ଜଣାଉଛି ଚିତ୍ତ ପଟ୍ଟନାୟକ ଘଟଣା ଦିନ 3ଟା ସମୟରେ ମୁଁ ବାହାରେ my lord page 18 ମୁଁ କୁନି ପଟ୍ଟନାୟକ ଜଣାଉଛି ଯେ ଚିତ୍ତ ପଟ୍ଟନାୟକ ଦି ପେଟିସନର ଘଟଣା ଦିନ 3ଟା ସମୟରେ ମୁଁ ବାହାରେ ବୁଲୁଥିବା ସମୟରେ ସେ ଏକ ମୋଟର ସାଇକେଲ ଆସି ମୋତେ ନେଇ କେଉଁ ଆଡ଼େ ଚାଲିଗଲା ସେତେବେଳେ ମୋ
Lordship, allow me to place the matter, and your lordship will permit me, I will remove the defect next week.
You remove the defect.
Several defects are
because
there.
I may not have time.
And today, it will take time. Your lordship allow me to place the matter. Next week I will remove the defects because the several defects.
What I'm saying is I don't have time because I have to rise a little early. So therefore, you cure the defect, I'll hear.
What has happened? Very small thing I want. The husband has come before my lords. Why I am placing? The husband is all along interested to take her wife and the child. The wife is not agree. She so much she has left the matrimonial house. Both the courts will have not considered. Even if in the evidence she has stated that yes, without information, I have left my matrimonial.
You come against which
Order of the revisional order, before the London trial court, she filed application under 125. That is allowed. Thereafter, she filed enhancement. Now, London trial court allowed. After taking evidence, during course of evidence, she has categorically stated, yes, mu so moto hoji pale I have left the matrimonial house, and I am not interested. No document torture. No.
What is the maintenance?
Maintenance 10,000 some odd. I am interested. My intention, your lordship fix up a date. Personal appearance of both the parties.
Let me issue notice, let us.
Again.
Issue notice. Issue notice.
Personal appearance of दी जन जगह से के ठीक है because her father is creating problem. But I am all interested to take my wife.
Okay, issue notice to opposite parties. Returnable करके दे तो 22-23 अरब दे. हाँ? 10th April.
ता भितर जदि गोटे हमर मेडिएशन को जदि गोटे दी जन को गोटे
नो आसिल नो पचारि कि मेडिएशन. आसन से.
Again. In the meantime, I will remove the defects.
Right.
Ovulation.
51.
May I plead your lordship?
Yes,
Modification. It's a modification, your lordship. Order.
What modification?
Last occasion, lordship specifically directed me to obtain the copy of the order passed by the court below pursuant to your lordship direction. This is a Belgium matter, your lordship. I was on bail on 41A of.
You are supposed to appear and seek.
Yes, your lordship. Pursuant to your lordship direction, I appeared before the court. And as your lordship specifically mentioned in the order.
Where is that?
That order passed on in this case, your lordship.
6/2/2024. Taking into
6/2/2024. He just recalled the NBW, your lordship.
Subject to interpretation being.
But he didn't exercise his right to release me on bail. He said, yes, because the 4 of PDPP Act is there, I will not allow your bail application.
Then you know the remedy.
That's why I am before. In the same case, your lordship, 2 other co-accused persons also appeared before this court, challenging the NBW order issued against them. And this honorable court has allowed their application, caused the NBW and directed the court below to release them on bail, your lordship.
I directed.
This honorable court, not this bench, your lordship.
Show me.
That is in CRLMC 3868.
Where is that order?
That is CRLMC.
But where is that order? Flag 1. But that is not the jurisdiction of this court. I don't.
Huh? 3658. What the Your lordship, I was on bail. Pursuant and as I could not appear on the summon date, your lordship, NBW was issued, your lordship. I appeared.
You were on bail?
Yes, 41A. I was on 41A. And it's a case, your lordship, where an accident occurred and all the villagers protested it and blocked the traffic.
Why don't you file a substantive petition challenging that order? In modification, what modification?
Only your lordship.
Modification means if there is typographical error, if I have committed some error in that order. There is no error. That's the standard order I pass. If subsequently, if the court below has committed some wrong, you have to file challenge that order.
Lordship, may peruse my prayer in the main application, your lordship. I prayed for quashing of NBW as well as direct the court below to release me on bail. On surrendering, release me on bail, your lordship.
Bail, this is not a bail court, therefore I didn't do anything. So you file a substantive petition challenging that. Rejection.
Religion bail.
I was on bail. This is Belgium matter. It's a Belgium matter. Oh, Belgium matter. So Belgium matter observation must be.
He was on bail. He was on bail, 41 bail.
41A.
NBW was issued, and I quashed it saying that go and take appropriate remedy. That remedy means he moved the application. Ideally, the court should have released him bail. Because 41 notice was there.
It's because 4 of PDPP Act, the minimum punishment is 1 year.
Because the other co-accused person, the coordinate bench has similar situation, they have said that release on bail.
Yes.
It is not coming under the Belgium matter.
Yes, Belgium.
No.
Belgium.
41. No, ସବୁ ଗୁଡାକ 41A ରେ ଥିଲା. all the cases for
He had
which
to appear one
which
second, person
Have you
submitted
shown
the-
this order to the land court below?
because your lordship
Have you shown it?
Yes, your lordship, because he has granted bail in those two applications
Because there was direction.
because there were direction, and your lordship may peruse this copy of the order sheet. Your lordship last time directed me to obtain the copy. And ମନା କଲେନି ସେ କହିଲେ ମୁଁ ତୁମକୁ ରିମାଣ୍ଡ କରିଦେବି that's your lordship may peruse
Taking into consideration
yes your lordship in obedience to the above order the honorable high court recall the imbue against the accused person named and then as he refused to grant me bail your lordship and I filed a time petition your lordship may peruse the last para. At this advocate for the accused filed a petition for appearing of the accused person had the time petition is allowed because he that is what the record is showing, but the what happened in the ground level your lordship I am submitting before the court your lordship.
you modified it, yeah, unnecessary.
Yes.
Right down.
Your lordship.
The body of the present application, petitioner seek modification of the order dated. Order dated 6/2/2024. The petitioner submits that the co-accused person in the similar condition have applied for cancellation of NBW issued against them, and the coordinate bench by the order dated 31/8/2023. While disposing of CRLMC number 3658 of 2023 and CRLMC number 3868 of 2023, the coordinate bench pass or same order है क्या? नहीं कौन लिख लो? हाँ file separate criminal MC numbers number 3658 of 23 and 3868 of 2023. The 23 challenging the NBW issued against them. The coordinate bench by the order dated 31/8/2023 and 30/8/2023 respectively allowed their petition and pass the following order. Last it लिख दो it कर दो ये page ये flag area अच्छी flag 1 रे अच्छी para 6 से बोलते para 6 ठीक है जी. The relying upon the aforementioned two orders of the coordinate bench, the counsel for the petitioner submits that similar order may be passed in his case by modifying the earlier order passed by this court on 6/2/2024. Accordingly, the order dated 6/2/2024 is modified and the following order is substituted. ये पूरा नहीं जो 6/2/24 para 1 to नहीं जो 1 to 3 नहीं जो 4 रे taking into consideration the aforementioned facts in submission at the bar, the order dated 5/8/2023 passed by the so and so पूरा लिख दो is set aside. Bhawanipatna is set aside subject to petitioner so and so कर दो तापरे पूरा
already paid your lordship that amount
पूराटा लिख दियो 4 नंबर पारा लिखी तापर लिखो if the petitioner is directed to surrender before the trial court within the aforementioned period and move appropriate application for bail. In the event that such application is moved, the same shall be allowed. Same shall be allowed on the same shall be allowed subject to any condition. Subject to the condition, the petition shall appear before the court below on each date of hearing. Each date of hearing without seeking exemption. Without seeking exemption.
Aforesaid period said 26th February.
26?
That your lordship may peruse page 3, para 3 on or before 26th of February. So that way
26 February को date look कर दो 5th
26 मार्च को तो
26 मार्च को ठीक February मार्च को ठीक
oblige yours.
Yes.
May I please, your lordship? This is the matter arising from the matrimonial dispute,
Yeah.
lordship.
You show me where is that
Yeah.
when notice was issued.
Can you report this file?
Let us see. Wait.
Another one.
I would have did
One such.
Service on opposite party number 2 has already been effected. However, none appears. Urgent 2. First.
You would have did fix it.
First.
Interim order to continue.
Interim order to continue.
Yes. Oblige.
Yes.